Welcome, everyone. Thank you for joining us so early today, getting our closed captions up and running. All right, they should be up and running. Welcome, everyone. My name is Christy Baglow. I'm the Director of Statewide Training at Florida Legal Services, and I'm really excited to have James Heaton with us today. Bless his heart, he reached out and offered to do this 3-hour training. I didn't even have to beg or bribe him. So thank you, James. As many of you know, James is a supervising attorney at Mission United at the Legal Aid Service of Broward County, soon to be the senior director of Mission United down there. So that's very exciting. It's going to be hard to find someone to replace James in his current position. So if you know of anyone, reach out. There's going to be big shoes to fill for sure. So today we have a 3-hour course on VA accreditation. Don't worry, we're going to take a short break every hour. We're not going to keep you bolted to your seats for 3 hours. But I'm excited to see so many people interested in helping veterans. Maybe you're already serving veterans, you just need a refresher. I always find it's helpful to listen to these courses and get a different perspective from different practitioners. And James just has a wealth of knowledge, so I'm really excited to share his expertise with you today. And we will take questions during the program, so you can just type them into the Q&A box whenever you think of them, and we'll pause at certain points to take questions. So without further ado, James, I'm going to pass it over to you.
Thanks, Christy. I really appreciate it. And thank you all for attending. And I know there's some more people rolling in right now. So we're going to give it like another minute or two. It's like popping popcorn where you don't want to stop too early where you still have some kernels left over. So we're going to wait a few minutes and let everyone attend. Everyone who plans to attend, come in. And let me launch my PowerPoint now just so we can get that going.
Yes, and CLE has been approved. So I've got that ready to announce at the end.
All right. Perfect. So as we kind of get started, I'm going to start with just a few things here. And one of the things I want to start is talking about pro bono opportunities. So on this slide are pro bono opportunities through our project here at Legal Aid. So Legal Aid Service of Broward County hosts the Mission United Veterans Pro Bono Project. It's a partnership between Legal Aid Service of Broward County and the United Way of Broward County. Many of you in your communities may have a Mission United program, and it may be linked up to your legal aid. If not, reach out to both entities if you're interested in coordinating these things. It's such an important service to the veterans in our community. One of the things that I suggest that you all do with your powers of VA accreditation are use those powers for good. If you're a private practitioner, take pro bono cases. This is such a needed service in legal aids across Florida and across the country. There's some amazing programs nationwide that can help out. If wherever you are, reach out to myself or Christy, and we'll definitely help put you in touch. The ABA's got a keen interest in this stuff. I'm sure your local and state bar associations have somewhat of an interest as well. If not, they should, because this is very important. So there's not always a program like ours here at Legal Aid Service of Broward County in your backyard, but I bet you with enough interest, you can be the person that starts one, or you can definitely find one if all you're looking to do is provide these services. So another thing too is talking about VA accreditation. Now, VA accreditation allows you to provide legal advice and representation to veterans in VA benefits claims and all types of VA benefits law. Now, if you want to use this video for accreditation, you need to be accredited prior to the date of watching this video, technically in order to count it towards your 3 CLE credits, but there are plenty of other opportunities out there, or you can just rewatch the recording later, right? I think that's how that works. And so this presentation is both VA accreditation CLE and also Florida Bar CLE. Florida Bar is granted 3.5 general credits for CLE. And that link there, if you just Google VA accreditation, you can get to their accreditation website and learn a lot more. They have a pretty active accreditation email address, which will help out. Now, this whole presentation has some basic objectives. And these are the objectives required for accreditation. We'll get into some intermediate level details. I try to not get into too many high level expertise details, but that's the nature of law. Sometimes there are some things that may be confusing to you. But remember, this presentation is a basic level course for VA accreditation. But with that being said, there are some intermediate level content. I try to do my best to go over some of the vocabulary that may be unique to you, especially if you don't work in the veteran space currently. We'll try and keep things as clear as possible. But these are the main objectives here for this presentation. And if there's any questions or any clarifications that are needed, go ahead and put that in the Q&A. And during our breaks on the hour, not on the hour, but when we reach that hour mark, we'll make sure we address those. Here's a very important slide that I put together as well that talks about some useful references. So I'm not going to go through each one of these, but I want to point out, and let me find my little handy highlighter, that this right here, one of the newest publications out of from the ABA, I actually have a copy of it sitting right next to me. I bought it the day it was released. It is amazing. We're going to talk a little bit about discharge upgrades during this presentation as it pertains to VA benefits, but this is also another crucial area of the law that is so beneficial to our veterans and can help out legal aid programs and other public interest law programs across the country if you learn how to do discharge upgrades. It takes a level of being able to read through minutia, have some skill in writing, and have the patience of the saint in order to do some of this discharge upgrade work. But it's very, very helpful. But we'll make sure that this PowerPoint gets sent around so you'll have this references slide as well. Now, let's kind of get into some of the meat and potatoes. This is going to be one of the most basic slides you'll see throughout this entire presentation and can be very helpful if this is your first foray into the military and veterans law space. Now, these common terms are used to help clarify some misconceptions. Sometimes people use the term veteran to talk about a military service member. Sometimes they use the word service member to talk about someone who's out of the military already. So just to be clear, service member is someone who's currently in one of the military branches. A veteran is someone who has previously served in the military. Seems pretty basic. Just a point of clarification for anyone out there who might have been confused. Another confusion is the difference between enlisted and commissioned. When you think about enlisted, these are the folks that are the working force of the military, often the boots on the ground, if you will. The folks that keep the military running on its day-to-day basis. On the other hand, individuals who are commissioned are the professionals of the military, the working professionals. Often folks with higher level education, sometimes through a military academy, sometimes through law school. These are the professionals of the military. And then there's also a reserve component, which is separate from active duty. Reserve is, you can think of it as a part-time component. Sometimes reserve members become activated, but for the most part, they are working on a less full-time basis. Now, for the purposes of this presentation, we'll get into a lot of the details where they need to be addressed, but we're mostly talking about enlisted or previously enlisted individuals who are now veterans. So this is going to be, for the most part, who we are addressing. So veterans who are previously enlisted in the military, which are going to be the overwhelming majority of your clients. Whether you're in private practice or at legal aid, especially at legal aid, the overwhelming majority of your clients are going to be veterans who were previously enlisted in the military. So let's talk about this journey that service members go on, and this could be its own presentation in itself, and probably will be one day. But we're going to talk about the journey from service member to veteran. But first, let's talk about the system itself. Let's talk about the Department of Veterans Affairs and how it got to where it is today. So the VA, if you will, is what we'll call it for short, was established right after the Civil War and was handled under three separate government agencies who handled three different types of the benefits that were offered to veterans who were leaving the Civil War, which were the majority of the adult male population in the United States at the time. So we had at the time the Veterans Bureau, the Bureau of Pensions of the Interior Department, and the National Home for Disabled Volunteer Soldiers. So these were three separate government agencies. One, Congress consolidated all these into the Veterans Bureau, still a government level agency. And then in 1930, it's a year that makes plenty of sense, the Veterans Administration was created through executive order, and it finally started an actual federal administration through the Veterans Administration. Now, after 1988, Reagan signed into law, but it went in effect under Bush in '89. The Veterans Administration was promoted to a cabinet level executive department and changed its name to the Department of Veterans Affairs, which is a name that we use today. So the VA is not the Veterans Administration, surprisingly. It is the Department of Veterans Affairs. So at the time, nearly about a third of the US population was eligible for VA benefits, and it oversaw departments under the VA. And those three departments were VBA, or the Veterans Benefits Administration, the VHA, Veterans Healthcare Administration, and the Veterans Cemetery Services. So here's a quick little breakdown of those three. This is today's VA. This is the makeup of today's Department of Veterans Affairs. Are those three departments? Now, this is one of the biggest issues that we run into at the VA is these lines separating these boxes should be more of like a solid black line in bold, because it's not very often that these three departments communicate with each other. They don't share a single simplified platform. The VBA, as you'll hear a little bit later, we'll touch on, has a platform called VBMS, which is the Veterans Benefits Management System, which allows you or a veteran service officer or accredited attorney the ability to access the veterans benefits file. And they handle claims, benefit claims and appeals, and determine eligibility for all other benefits here, which is a big thing. Now, they determine the eligibility for the most part for the VHA, though that's really one of the only times they communicate is when they need to. So things become difficult, and I'll leave it at that, but just understand that there's a level of difficulty between communication of these departments. And it all stems from the history of the VA. So now that you understand where the VA is at today and separated into three separate departments, we're going to spend most of our time talking about the VBA, the Veterans Benefits Administration, where we do talk about the VHA where necessary, mostly about the VBA. Now, the number one question on everyone's mind, James, who is a veteran? I know, that seems like an easy question. I bet you if you polled all of your friends and family members right now and you ask them, who is a veteran, they'll say, oh, anyone who served in the military. Well, I personally agree that that should be the definition of a veteran. And for the purposes of our program at Legal Aid, it is the definition of a veteran. Is if you served in any aspect of the military, you're a veteran in our eyes. Unfortunately, the law says things are not as black and white as we wish they were. I want to present to you here two separate definitions, one on the federal level and one at our state level here in Florida. So Title 38 of the United States Code, and Title 38 governs both for the United States Code and the Code of Federal Regulations, VA matters. So Title 38 of the US Code states that a person who served in the active military, naval or air service, and who was discharged or released under conditions other than dishonorable, that is a veteran. So under conditions other than dishonorable. The Florida Constitution here in subsection 14 of 1.01 lists similar language here, but then says who is released or discharged under honorable conditions only. There's a bit of a distinction here between conditions other than dishonorable and under honorable conditions only. Furthermore, the Florida Constitution goes on to say, unless you got a discharge upgrade, even if the VA came back and said that you served honorably, if you don't have under honorable conditions discharge, you're not a veteran under Florida Constitution. So now we'll get into that in just a second too, but the main focus that we're going to be having throughout this presentation is Title 38 of both the USC and the CFR, the USC being the law and the CFR being the regulations governing this area of law. Now, the under conditions other than dishonorable, you're going to hear in just a moment how ambiguous that is. It's essentially governed through an administrative process by the VA called a character of service determination, sometimes a CSD, I've heard it called a COD, but character of service determination is a process that the VA uses to determine what under conditions other than dishonorable actually means when it's in question. And we're going to get into more detail about that as this progresses. Now there's a separate process through the military called a discharge upgrade, sometimes depending on the board you're applying to, the correction of military records, but generally speaking, a discharge upgrade. And we'll talk about the distinctions between those two in just a moment. But just so you know, there are two separate processes for either determining a eligibility for VA benefits or creating eligibility for VA benefits, which one's through the VA and the other's through the military. Now, when we talk about the Florida Constitution definition and the impact on that, the biggest implications are through state-specific benefits. So when I first wrote this presentation, it definitely included Veterans Treatment Court. These days, not so much, as there's been a lot of great advocacy here in Florida to expand eligibility for Veterans Treatment Court to include pretty much all veterans and all folks who served previously in the military. But some state education benefits, other state-specific programs will depend on state property tax exemptions, will depend on a individual's status as a veteran under the Florida Constitution. So it's important to know what realm you're operating in for the most part, and specifically for this presentation and accreditation, we'll be talking about Title 38. But it's important to know that there's some distinctions to be made. Another interesting distinction is your state, if you're not residing in Florida, may have a different definition of veteran. A veteran in one state may cross state lines and not be a veteran in that state. Will that affect their VA benefits? Probably not. But will that affect their ability to enjoy the benefits of a veteran under programs of that state? It may. So it's important to look and to understand where you're operating, what your client's asking for, and what it is that under what jurisdiction that's operating. Now, we're going to talk about a DD214 in a second. If you don't know what that is, you will know soon. Don't worry. Now, let's talk about things to consider about a discharge from the military. And when we're talking about who's eligible and who's a veteran, discharge from the military is going to be the first place that we look. Here I have lined up for you the definition from Title 38. It's our friend. It's going to be following us a lot, and broken down into these three main categories of what we look for. So what we're considering when we first meet with a veteran who may have had an eligibility issue is we want to know how long they were in the service. And that includes any previous enlistment term. So if they have multiple DD214s, or if they have one DD214 that they've been in for a substantial period of time, it's always good that we always ask, do you have any other enlistment terms other than this one on this DD214? And they'll know. Well, they should know. The second is, in what capacity did they serve? Does this person have a lot of active duty time? Have they only served in the reserve, in a reserve component? Have they only served in the National Guard? Were they an officer? Were they enlisted? These are all things that are going to be important to know. And in just a moment, we'll take a look at the DD214 and you'll be able to see how you figure that stuff out. But these are all questions that should come up during your initial interview with your clients. And third, and possibly at least as important as the total length in service, is character of service. What was their narrative reason for separation? And these are terms of art here: narrative reason for separation, character of service. What type of discharge did they receive? How did their military service end? Did it end abruptly through an administrative separation, which don't worry, we'll talk more about? Was it a punitive discharge? Did it just end naturally? How did their military service end? Did they retire? All this, was there a disability involved? All this stuff is important to get from your client at the initial interview. The good part is once you get proficient at reading DD214s, you'll be asking these questions and probably already know the answer. So it's something that's going to be helpful to add to your tool belt. There are questions focusing around these three broad topics of when we're first interviewing our clients. Now, when we talk about discharges, we're talking about the form of all forms, the DD Form 214, sometimes called the DD214, sometimes as my one of my staff attorneys calls it, DD214. I love it. I love how she calls it DD214, no matter how much I keep calling it a DD214. Keep doing you. But this is the form for veteran separation. This is the form that every veteran receives or every service member receives when they become a veteran and they discharge from the military. Sometimes it's handed to them, sometimes it's mailed to them, sometimes it's thrown into military personnel files somewhere deep in the archives, never to be seen again, except for when you try to request it. But it exists. If the person served in the military and they told you, oh, I never got a DD214, something's wrong. It exists. It's also, unfortunately, one of the most forged documents. I recently had a client who had a pretty decent forged DD214. Though if you've seen enough of these, you kind of start picking up some inconsistencies. And after a little bit further questioning, we realized that it was clearly a forged DD214. And but I would always default to truth on these and not get bogged down on thinking everyone has a forged DD214. It's not going to help you. But looking at especially because when you look at older ones too, they can have some weird things on them. Because there used to be less uniformity, and even modern ones. Anyway, don't worry about that. It's a very important document here, and we're going to break it down into its sections. And I have our DD214 broken down into 3 sections here of our veteran. An important note is that, as I mentioned earlier, veterans with multiple enlistment terms may have one DD214, or may have more than one DD214, or they may have each enlistment term reflected on that single DD214. And you may be saying, James, what did you just say to me? Don't worry, I'll explain it further in 1 second. So first section of the DD214, we're going to be looking at some biographical and demographic information about this individual. This DD214 is a highly sensitive document. It contains very sensitive, personally identifying information and should be kept private at all times. So here we have the individual's full name. We have their social security number. We have their date of birth. We have oftentimes, in some of the older documents, we have a parent's name. We have their home address when they first joined. We got a lot of information on a DD214 that should be kept private from all prying eyes. Now, this DD214 will also show important information. What component, what branch and component the individual served. Here we have the Army, and we have RA, which is regular Army. So this is active duty Army. We have their grade, rate, or rank over here. This individual was a sergeant, an E5. So here, from looking at E5, we know E stands for enlisted. If it said O5, that person may be an officer. It would also be reflected here as their O5 grade as well. The rest of this information can be helpful at times, though the main things we're looking for are their where they serve, or what branch they served in, and it's maybe helpful too to see their grade and rank, especially if you have someone who says they served 4 years and it says E1 and PVT private here. Something that should be the first sign that something probably happened in their military service that made them reduce rank. So this is the first third of the DD214. The second third is a lot of the meat and potatoes of the DD214. Now that we know who the person is, this tells you how their service was, how long they served, and what we need to know. So let's start with this box here that says record of service, because this is going to be your guideline. In addition to asking that question of, do you have any other enlistment terms or any other terms of service other than the one presented here on the DD214? This will help you understand that. To you right now, to the untrained eye, this may look like a bunch of jumbled up numbers. And I'll tell you, oftentimes throughout the years, the military has changed how this record of service box has been laid out. So you may see this one. This is how they're laid out currently, but you may see them look a little differently, and I'll explain to you in a second. And even on here, there's some inconsistencies, but with a little bit of intuition, you can figure these out. So let's start with this first box. So this is the date that this individual entered active duty in this period, and this period refers to on this DD214. So they entered, when was this? We have August 21st, 2002. Pretty easy, right? So 2002, August 21st. Now let's go how long, and right below it is when they separated. So you can see all that, figure out how long they were in. But the military does the math for you right here. Net active service, this period. Here, the years are used a little differently. We have 3 years, 10 months, 10 days. Once in a while, when I'm talking to our clients, when we have a DD214 in front of us, I'll say something like, oh, I see you served 3 years, 10 months, and 10 days. Oftentimes, your clients are impressed with your specificity on how long they served, and it's something fun to do. It takes zero effort and helps build a little rapport between you and your client by them saying, oh, this person actually knows how to read a DD214. I bet you they know how many years, months, and days they served. So here you'll also be able to see any prior active service, prior inactive service or reserve time, guard time will be here as well. Foreign service. Now this right here, this box right here can be very important and very illustrative of your client's military history. For example, this individual here, we have 3 years, 3 months, 13 days of foreign service. Now, based off of this individual's time in service, we have from 2002 to 2006. Having 3 years, 3 months, and 13 days of foreign service probably means a deployment to Afghanistan or Iraq. Now, when we're looking at this, one thing that came to my mind immediately when I saw this DD214 was this guy was back, or he was overseas 3 years, 3 months, and 13 days. Added 3 years, 10 months, and 10 days of total active duty service. Wow. That is something that should be important to note in your brain and will help inform your evaluation of the needs of this veteran, and also help inform certain services and help you understand your client a little bit better. So those are the most important parts of this record of service. Now, a couple of other things here, and this will help inform you again of who your client is. So here, when we look at primary specialty in the Army called an MOS, you can always ask your client, what was your MOS in the military? And this guy would probably tell you 11 Bravo. And if you didn't know, you'd say, well, what's 11 Bravo? And he'd say, oh, infantry. And what works here, infantry. So this individual, 11 Bravo, infantryman for 3 years, 4 months. Infantryman, as you can imagine, front lines, boots on the ground, combat, however you want to say it, or however antiquated terms that used to be used. Infantry is who this individual was. So you kind of start getting a better understanding of this individual's service. We can move down here, and oftentimes, before we move on, when you ask them for their MOS, they'll tell you a combination of numbers and letters, or numbers and a letter. Don't feel bad if you ask them and they say, oh, it was 42 Charlie. And you're like, okay. Well, what was 42 Charlie? And they'll tell you what that was. Also, again, builds that rapport, helps build a conversation between you and your client. Going down to box 13, this just kind of gives you an overview of this individual's decorations. This is where they had combat service. You see Afghanistan Campaign Medal, which is helpful to know. A National Defense Service Medal, which means some overseas service. If they had a Purple Heart, it may be in here. This is just important to kind of understand, though no need to harp on it too much. Sorry about that. Also, the remarks down here, box 18, very helpful as well. It's going to tell you actually their deployments. So here we see service in Iraq between this date, this is July 16, 2003 to February 17, 2004. And we also have service in Afghanistan between these two dates. So our suspicions were correct that the foreign service was in Iraq and Afghanistan. Lastly, in this box or in this area of the DD214, very important for benefits sake, though not always a determining factor, but helpful. Member has completed first full term of service. Keep that in mind when you see that. You'll see sometimes they'll say member has not completed first full term of service. Just know that if it says has not, you may have a barrier there that you may have to overcome. My dog was not happy with that, but just know that this can be helpful, though it's not going to be this is not set in stone an eligibility determination. Now let's go down to the the bottom third of the DD214. On these member 4 DD214s, there's several different types of DD214. On this member 4 DD214, it will have this special additional information. Some forms don't. For the purposes of your records and understanding your client, you should get a copy of the DD214 that has all of this additional information. Really helpful. So here we can see the type of separation right up here. Release from active duty, easy. It might say something else up there for their type of separation, but release from active duty most commonly. So for our clients, character of service, honorable. This is where it may have a different type of character of service in there, which we will go over all of them in just a moment. Right now you may think honorable or dishonorable. Unfortunately, not the case. So here, this box will tell you their type of character of service. This will have the legal separation authority. So under Army Regulation 635-200, Chapter 4, that was the authority this person was separated. It's going to be important later on for potential discharge upgrades or character of service determinations. Here as well, these are two types of codes that are used for the individual's ability to re-enter the military for the most part. And then here's probably the most important box other than character of service in my opinion is the narrative reason for separation. Let's get it nice and highlighted. That right there will tell you why the person left the military. It can be something so as benign as completion of required active service. This guy probably was on a 4-year contract, served 4 years, and was out. Easy. It could be something like misconduct. It may say something in there like homosexual activity, or it may say something in there like retirement, or it could be a whole host of things. And this is going to be in a very important box to understand both why the individual was released from the military and also some other relief that may be available to them. For example, if this says homosexual activity and they were released sometime in the 80s, before even in the 90s, before the repeal of Don't Ask, Don't Tell, you know automatically that this may be an additional service that you can assist the veteran with that's fairly low-hanging fruit. But we'll get into that slightly in more detail later, but it starts going a little bit outside of the scope of this presentation. But just know narrative reason for separation, very important box. So let's talk about compensation discharge. About these briefly, but I want to go into a little bit more of a deep dive. So these are 3 of the main ways to be discharged, and not the only 3 ways, but 3 of the most common ways. So the first would be a veteran having their ETS or expiration of their term of service. They finished out their contract. They're done with their military obligation. As with our veterans who gave us his DD214 to use, that's what happened with him. Most common way that a service member is discharged from the military is through their ETS. You may hear, oh, my ETS date, which was essentially the end of their contract date. Additionally, a veteran may be administratively separated from the military. The ETS, this is a separation prior to their ETS. And I wrote that twice. That's how nice I thought it was. But it usually, this is due to some type of misconduct. and often results in a less than honorable discharge, which we'll get into more detail in just a moment. However, it can also be used, sometimes administrative separation can be used for other things such as certain family obligations. Maybe the veteran just became a single parent because of the death or disability or incapacity of another parent or a co-parent, and now they have an obligation to take care of their family members or young minor children. That could be a reason to be administratively separated. Will likely result in usually an honorable discharge or and whatever the discharge is that's appropriate. May also be for a minor disability or combination of lingering disabilities as well. Now, a court-martial may be another way to be discharged. Court-martial is a military trial. It is a criminal proceeding. So the veteran will, if convicted at court-martial, will likely receive a punitive discharge, possibly confinement, a permanent criminal record in their federal criminal record, and a very difficult time or likely impossibility of getting benefits from the VA. And in a couple slides, we'll get into more detail about the characters of service and the difference between punitive and administrative separations. But just know three most common ways. Also, retirement. Folks can retire from the military. It's common as well. Most of your clients, if you're working in a legal aid setting, won't be retired from the military, but some may. Now, a service member may retire after 20 years of active duty service. That's probably the most common way. Then they'll be able to still establish VA benefits through the normal administrative process, as all of your clients will have to go through. They may be eligible for private health care through TRICARE for life, for often them and their dependents at times. They may also be able to begin receiving military retirement pension, which is separate from these VA benefits that we're going to be talking about. It's taxable. It could be subject to dissolution. We're not going to get into that now. They may also be able to concurrently receive both VA compensation and military pension. And I just want to point out here, just note that these are two separate types of benefits. Don't confuse VA military pension and VA pension. Military, VA, not the same things, especially when it comes to benefits that are being paid. Military is the military. It's the Department of Defense or the individual branches, the Army, the Navy, the Air Force, Marine Corps, Coast Guard. And the VA is the Department of Veterans Affairs. So one thing to kind of write those two things on the top of a piece of paper and draw a line right between them, two separate jurisdictions. Also, a service member may be medically retired as determined by a medical board, similar to the administrative separation process. A med board separation will retire someone due to medical purposes. A little bit more on that right now. Discharge due to disability, also known as a disability retirement or medical retirement. Oftentimes you'll hear your client say, oh, I got an honorable medical discharge or a medical honorable discharge. Unfortunately, that's not one of the characters of service. You might have been discharged honorably for medical reasons, but a honorable medical discharge is not a thing, though a medical retirement is. Don't get too bogged down about this. Just know that it's a possibility that if your client was disabled while in the military, they may be entitled to medical retirement, and also it may be the basis of a future discharge upgrade to obtain medical retirement. Again, not really inside the scope of the purposes of this VA accreditation, but just know that this exists, that the discharge due to disability or retirement due to a medical disability is a way that someone may leave the military service. And that will clearly say on their DD214 retirement or medical retirement. So let's start talking about VA benefits and show one of our first rules or rules based on the regulation for VA benefit eligibility. So we're going to talk about the general rule for benefit eligibility. Now, generally speaking, and here we have right here our handy dandy Title 38 definition of veteran. We have a person who served in active military naval air service, discharge or release under conditions other than dishonorable. So we can break this down into these two general rules for eligibility. And we're going to be focusing on, generally speaking, the character of discharge, and the length of service. So generally speaking, this is our first general rule. The veteran must have 2 years of honorable service to be eligible for VA benefits. So 2 years, 2 consecutive years specifically, of honorable service. That's the first general rule. Remember, general. So let's break this down into its 2 constituents: character of discharge and length of service. So starting with character of discharge or character of service, we're looking for under conditions other than dishonorable. Now, what does that mean? In front of you, you have these 6 potential words that can be listed in this character of service box on the DD214. Unless you're looking at an older discharge document, an older DD214, these are really the only 6 things you'll see. So we have honorable, we have general under honorable conditions. Both of those are listed in green because green is good. And green means go ahead and get yourself some benefits. You'll hear one exception in a second, but go ahead and get yourself some benefits based off your character of service. Next, you have an other than honorable. This is going to be the area most contention with your clients are veterans who come healthcare or access to benefits other than honorable discharge. So just keep an eye out for this. This is an administrative separation, administrative discharge, usually based on misconduct or some subpar performance. Lastly, well, maybe second to lastly, we have these 2 in red. Red means bad. We have comic discharge, BCD, sometimes called the big chicken dinner, and a dishonorable discharge. These 2 are punitive discharges. That's why they're in red, because red is bad and punitive is bad. So these are punitive discharges that can only be assigned through the sentencing of a court-martial. These are the outcomes, the disposition of a court-martial, bad conduct discharge, or dishonorable discharge. When you see these on the DD214, you can, probably get the impression that something bad happened here. Not saying that your client's a bad person. Good people do bad things. But know that there was some higher level of misconduct that was tried at a court-martial, and also there was some sort of conviction at a court-martial. Now, the biggest issue with these are going to be for the purposes of getting your client benefits, and we're going to talk about that in greater detail a little bit later in this presentation. Lastly, the uncharacterized or entry-level separation. Now that's reserved for individuals who are discharged in fewer than 6 months of military service. So it's not good, it's not bad. We'll talk more, and the next slide's going to illuminate this stuff a little bit more, but entry-level separation or uncharacterized may be on there as well. Oftentimes it's someone came into the military, didn't make it through boot camp, and their command didn't really know enough about them to designate honorable or any other type of character of service, so they gave them uncharacterized. Okay, so these are essentially the characters of service that you see here. Let's break it down a little bit more. So we're looking for conditions other than dishonorable, and you might say, James, all of these are other than dishonorable except for dishonorable. And I say, yeah, you're right. If you talk about on a layman's terms, but this is the law we're working with. So we have to understand what the VA means by conditions other than dishonorable. Now, the VA talks about here under 3.12E. So 3.12 is going to be your regulation. 38 CFR 3.12 is the main regulation based on character of service for eligibility purposes. Now, generally speaking, under 3.12E, honorable and general discharges will allow for VA benefits for the purposes of character of service. Now, remember, we're going to be looking at character of service plus length of service. So for character of service, honorable and general discharges, you're good. Check that box off, character of service, check. There is one benefit, however, the GI Bill, that requires the veteran to have an honorable discharge listed on their DD214. It's possibly the only benefit that requires a direct honorable discharge listed on the DD214 to be eligible for. I'll tell most of the discharge upgrades that we get from people who have a general discharge are saying, well, I need to go up to honorable so I can get the GI Bill. But just know, this is one of the only benefits that is, for purposes of the VA, that are different between a general discharge and an honorable discharge is the DI bill. Now, when we're going down, we're talking about other than honorable. And this is where, drafters of these regulations really shine with their foresight. Is other than dishonorable, like, come on, guys, you couldn't have made this a little easier. So other than honorable under 3.12C and 3.12D, these are going to bar to compensable benefits. So bar to compensable benefits based off of other than honorable. However, they may allow access to healthcare for service-related disabilities, but ultimately will require the VA to go through an administrative decision. So what does that mean? Let's break that down a little bit, because this is important. And we're going to take this in reverse order. So first thing that happens, or should happen, when a veteran presents to the VA with an other than honorable discharge, is that veteran, or is that the VA should start an administrative process to determine whether this veteran service was under conditions other than dishonorable. The VA is supposed to start that process upon application for any benefit by a veteran with an other than honorable discharge. Now, that doesn't always happen, but it's the way it's supposed to happen. So that's one of the things that we look at first is when a veteran comes in and says, oh, I have an OTH, I have an other than honorable discharge, and I was turned away from VA healthcare. I want to take a look at that veteran's personnel file to see if an administrative decision has been rendered. Across the country and historically, locally, the VHA, the VA healthcare system, has turned away veterans who present with an other than honorable discharge on their DD214. So without going through that administrative decision. Now, there are times where so that's supposed to be the first thing that happens is that administrative decision, and the outcome of that administrative decision will say whether that veteran, whether their character of service was under conditions other than dishonorable or honorable for VA purposes. I'll give you a quick example. We had a veteran who was discharged with other than honorable discharge due to one single instance of testing positive for marijuana. It was under the Navy's zero tolerance policy and got an other than honorable discharge for that one point of misconduct. Now, when he applied for VA benefits, the VA said, yeah, you have an OTH, but for reasons that you'll learn later, it was not under it was under other than dishonorable conditions. It was honorable for VA purposes. So he was able to get access to benefits, not based on his this barred character of service. So just know that it's just because it says other than honorable on the DD214, it does not automatically mean a bar to benefits, but will likely need some finessing in order to get your client access to benefits based on their character of service. So now that we've looked at these administrative separations, and we can either put a check or a question mark or an X of service when we're interviewing our clients, let's move on to the red, the punitive discharges. Now, when there's a punitive discharge, that's going to constitute a bar to all benefits paid under the VA. Yeah, it becomes extraordinarily difficult to get benefits from the Department of Veterans Affairs when you have a punitive discharge, and may require either a discharge upgrade if possible, or some further digging to ensure that everything was handled correctly or not. Now, I'll tell you, one of the most common ways that we're able to get our client benefits when they have a punitive discharge is if they had other terms of service, other periods of other enlistment terms, other periods of service where they may have been discharged honorably and allowed to continue to serve. So we're always looking for that, and we're always looking for some potential ways to get individuals benefits, but just know this is an extraordinarily high bar when you have the conviction of a court-martial. Now, under 3.12K1, an uncharacterized discharge that we talked about is considered conditions other than dishonorable for character of service. But you're going to learn in a second where someone with an uncharacterized discharge usually runs into issues with VA benefits. So keep in mind, this is just one part of the puzzle: character of service plus length of service. So once you have character of service set, you're going to move on to length of service. to determine how long has this individual served. So looking at Title 38 3.12a, so 3.12 is character of service, 3.12a is length of service for eligibility purposes. 3.12a establishes a minimum active duty requirement for VA benefit eligibility. Here we have for enlisted individuals, 24 months of continuous active duty. Excuse me. And for reservists, we have the full period for which a person was called or ordered to active duty. So if a reservist was called to active duty, take a look at this. So like I said, this is not something we're going to be doing a deep dive into at this point, and it's going to be on a case-by-case basis for each of your clients. But mostly we're going to be looking at this, the 24 months of continuous active duty. Now, who does that apply to? It applies to people who were originally enlisted in a regular component of the armed services after September 7th, 1980. So that's going to be one of the first things you look at is when your client enlisted. Did they enlist after September 7th, 1980? Did they enlist before September 7th, 1980? We're also looking at anyone who enters active duty after October 6th, 1981 without a prior qualifying period of service. So did they enter active duty? And this could be someone who entered active duty from a reserve component after October 16th, 1981. So these are some of the dates that you want to keep in mind, or at least have handy, or just know that, oh, it was sometime in the early 1980s. That should be a good enough basis to trigger whether you need to look further into this regulation. And this is 3.12a subsection C. Now, before September 7th, 1980, all they had to do was complete their required period of service. So the period of service of which they were required, and we'll talk about that in just a moment as well. But generally speaking, the reason for that being is around that time, the military started having more uniform enlistment terms. So you started seeing across all military branches more uniform enlistment terms of usually 4 years active duty and a couple years of a reserve component, or 2 years and 6 years. There were more uniform active duty enlistment periods and contract terms. So that's where this 24 months of continuous active duty comes. And so generally speaking, your modern veteran has 2 years, 24 consecutive months of active duty, and meets meets this character of service requirement of under conditions other than dishonorable. They're going to be eligible for pretty much all of the VA benefits under the sun, assuming, barring this right here, but all the benefits that they're entitled to. They're able to open the door to the benefits and take a step right in and start seeing what they're eligible for. Now, for the most part, clients who's before you is going to have some sort of stick or some sort of irregularity or some sort of barrier to accessing VA benefits that you're going to have to address. Now, another part of length of service that I want to talk about are some of the exceptions for length of service. So we talked about service prior to 1980, also a veteran service member who is discharged or released under a hardship or early out, which, early out as defined under U.S. Code, Title 10 of U.S. Code 1171, or a hardship like we discussed with having the need to take care of their dependents under 1173, that interrupted their length of service. That could be an exception to length of service. Also, these two, we're not going to read them directly, but are actually these three, because they're all kind of tied together. And that is, briefly speaking, or generally speaking, a veteran who has a compensable service-connected disability. So what does that mean? That means if the VA has determined that your client has a service-connected disability, meaning that they have a disability that was related to their military service, as proven by, or at least as likely as not related to their military service, as shown by a credible medical evidence, they can forego this length of service requirement. So this is going to be the most common way to overcome length of service. So what does that mean? That means if you have someone who is discharged under uncharacterized discharge due to a hurting themselves during boot camp and not being able to continue on, or and the military just wanting to get rid of them. And that person still has a disability that is, plausibly connected to that injury from the military. They can get service-connected disability benefits for that, and therefore forego the length of service requirement. They might not have the 2 years, but because they have the character of service, we can check that out. And they have this exception for length of service. They should, that's a thumbs up. Good to go. This is going to be the most common way to get around that length of service requirement. So you may have a veteran come in and have an honorable discharge, but only have 22 months of consecutive service, and they say, I don't know what I need to do to get access to VA healthcare. The VA saying I'm not eligible for healthcare, but I have an honorable discharge. I was in for 22 months. I served after 1980. What am I supposed to do? Getting a service-connected disability will overcome that. A discharge upgrade will not overcome that. Telling them to go re-enlist into the military for 24 more months is not a plausible way to do it. So getting them service connected will forego this length of service requirement. Best way to do it. So let's look at a revised general rule, and then we're going to take a little break. But the revised general rule here, as we take a look at it, is a person who served in blah blah blah. We already know that the Title 38 rule. So generally speaking, the veteran must have 2 years of honorable service as determined by the VA, or meet an exception if their honorable service was for fewer than 2 years. I think that's a great way to think about it, is either straight away you have 2 years plus honorable, or and honorable obviously as determined by the VA, or you have honorable as determined by the VA and you meet an exception for having fewer than 2 years. So that's going to be the best way to look at this revised rule. So we're going to take a quick break here, and by quick break I mean let's do 5 minutes. It's 9:57 right now. We'll come back at 10:02, and we'll get into the next section. So at this point too, I'm going to take a look at some of the questions, and we'll answer them during this 5-minute break. And I'm sorry if my face disappears a little bit during this presentation. I'm on my legal aid issued laptop, which does not have the best of the camera view, so I do apologize. I'm hoping all of you who are joining us here on this Monday are finding this exceedingly helpful. This first probably about hour and a half of the presentation is really focused on understanding accessing VA benefits and specifically VA healthcare and VA compensable benefits. So it's a lot of the minutia and a lot of the more detailed aspects of it. My dog's come to join us. She wants to play. Yeah. She gets jealous when I talk to strangers that are not her. I was looking at the list of folks who are joining us, and I see a lot of you are not strangers, so it's great to see a lot of you. All right, we're going to be starting in about 30 more seconds. Again, remember, if you have any questions, please put them in the Q&A. There are no dumb questions. I really want to see as many questions as you possibly have, even if you think that they're kind of ridiculous. Believe me, this stuff is pretty complex. There's a lot of moving parts, so I'm happy to provide any clarifications. One other thing too is, as Christy had mentioned, as we have like about another few seconds here, as Christy had mentioned, we here at Legal Aid in South Florida, Legal Aid Service of Broward County, will be hiring for the supervising attorney of the Veterans Unit here at Legal Aid. Christy's going to share that job posting. Please go ahead and share that with your friends and colleagues. We've got a couple of awesome candidates in mind already, but we're definitely we're looking for the right folks in this place. And the application process is open on a rolling basis. We're hoping to start interviewing soon, as soon as this week, if possible, fingers crossed. So just you can go ahead and email me directly or reach out to Christy just with your resume and cover letter if you're interested in that position. But definitely a great opportunity to grow in this veteran space and really being able to work at a pretty awesome grassroots, boots on the ground organization doing a lot for veterans. All right, so let's carry on. Let's move on and let's do a little bit of a deeper dive into these bad paper discharges, as they're called. So let's talk about how you can overcome having an other than honorable discharge. We're going to talk about explicitly why an other than honorable discharge prevents you from getting benefits under 3.12. And we're going to talk about how good VA is at wording things with the insanity exception. So digging deeper into discharges, because alliteration is fun. An OTH is usually an administrative discharge processed through the chain of command, but can also be the sentence of a court-martial. So understanding that an OTH is punishment. It is something that is given because your chain of command or a military tribunal believed or had enough evidence to believe that you did something wrong. A veteran or a service member may receive an other honorable discharge in lieu of a court-martial. So, hey, we're going to court-martial you, but instead of going through this process, just take an OTH and we'll get you out of here. That could be a way to do it. They may have a hearing before a discharge review board and administrative board, though sometimes that's waived. Usually just a pencil whip checklist of, hey, you want to get out of here quicker? Just waive this. The veteran will sign an acknowledgement of potential consequences. Hey, these are all the things that can happen if you accept this OTH. The discharge process is often started at the suggestion of the chain of command after serious or repetitive misconduct. And we'll talk about that. And there's usually, not always, but sometimes the opportunity to rehabilitate the misconduct. There's so much discretion is really the point of the administrative discharge. So much discretion from the chain of command that it causes some of the difficulties. Now, one of the things, and this is one of the newer bullet points that I added to this presentation a couple of months ago, was that the command must follow procedural guidelines when going through an administrative discharge. If not, it can be the basis of overturning it through a discharge upgrade at a later point. Again, if you are interested in practicing discharge upgrades, I'm sure that we can get you in touch with plenty of other resources for that as well. Also happy to answer any questions for upgrades you might have either during or after this presentation. Now, overcoming an other than honorable discharge, and I'm going to abbreviate this as OTH probably for the rest of this presentation because it's so much easier to say. So an OTH will often act as a scarlet letter on the veteran's DD214, and that's what I was talking about before. Walk into the VA, the VA greeter says, hey, let me see your DD214. They take a look at the OTH and they go, oh, we're so sorry, we can't help you. You need to get a discharge upgrade. Unfortunately, that's not how things are supposed to work. As we learned before, that person's supposed to say, oh, well, here, you can go to enrollment and enrollment will, see if they can help you further. Even sometimes enrollment will tell them, oh, you have an OTH, we can help you. But that's not how things should work. They're supposed to be often either enrolled on an emergency basis until the VA can determine whether their OTH is going to be a bar to benefits. Now, through that, we talked about that administrative process. It's supposed to be triggered when a veteran applies for benefits when they don't have a clearly honorable or general under honorable conditions discharge. I'll tell you the easiest way that we found is just having them apply for benefits. Even with an other than honorable discharge, these days you can apply for service-connected disability for healthcare purposes. You could even apply for a certificate of eligibility for a VA home loan to trigger a character of service determination. And these are all potential ways to get that process started. Unfortunately, one of the things that we always advise our clients when they have an OTH and they have these barriers is that it may take some work. It may take some fighting in order to get them access to VA healthcare. And one of the good things about an attorney, being an attorney and being an advocate for these clients is I get to be completely honest with them and tell them everything that we know, everything that we don't know, and set proper expectations for them. Now, we're going to talk about the insanity exception later as a way to overcome an OTH, and we'll touch on discharge upgrades briefly as well. So why is an OTH a bar to benefits? Why is it not allowed? So we're going to break this down into two types of bars to benefits under the law. So we have Title 38, USC 5303, which lists statutory bars to benefits in the regulations of 3.1c. So these statutory bars, these are 6 reasons why benefits are not payable. So here we have benefits are not payable if the discharge was for any of these 6 following reasons. And let me get out my trusty highlighter again, because we're going to talk about some of the most common ones. And these are statutory bars to benefits. These are the bad ones. Most commonly, sentence of a general court-martial. AWOL. Those are going to be the most 2 common ones for statutory bars. I'm not saying that these other 4 don't exist, but it's good to know them. It's good to understand them. And sometimes you might get the wayward VA service representative who says, your client's not able to get benefits because they're barred under 3.12c. And they won't tell you more. And you say, well, under which reason? And they go, oh yeah, one of these reasons. And you go, yeah, no, I get it, but which one? So to know and to kind of understand where they may be coming from when they're stating that your client is barred under 3.12c. But for these 2 highlighted portions, these are the 2 most common. Now, under AWOL, there's a certain there's some factors to overcome having more than 180 days of AWOL, some compelling circumstances, and here they are. They're listed directly in the regulation under 3.12c6. These are the factors. I'm not going to go into full detail, and there are actually more words in this, but I'm not going to go into the full detail about each of these factors. Just know that there are compelling circumstances that can be used to overcome a 3.12c bar when there's AWOL for more than 180 days. Now, let's move on here. Other bars to benefits, we have regulatory bars under 3.12d. So 3.12d these are the regulatory bars. These are the less serious bars to benefits. And we'll talk about the distinction between those 2 in a second, 3.12c and 3.12d. But essentially, a discharge from any of the following enumerated reasons is considered to be under dishonorable conditions. There we go, finally, ding, 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 ding. We have them defining, under dishonorable conditions for you. So any of these 3.12D are considered to be under dishonorable conditions. So here's acceptance of an undesirable discharge. Let's throw in more words that aren't real terms of art. Undesirable discharge in lieu of general court-martial. So if your client was going to be going through a general court-martial, not a summary court-martial or special court-martial, but a general court-martial, the worst of the three. And instead they take in other than honorable discharge. It's going to be a 3.12D bar. If they had an offense involving moral turpitude, this comes up once in a while, not super common, but comes up once in a while. So generally speaking, a conviction of a felony or a felonious act, serious misdemeanors sometimes, they're often in coordination with a civilian offense, but an offense involving moral turpitude that resulted in an other than honorable discharge is going to be a 3.12D bar. The most common 3.12D bar, ding, 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 willful and persistent misconduct. We even have more slides about it. That's how important it is. That's going to be the most common reason. So they'll say, yes, your client got an other than honorable discharge for regularly being a jerk and fighting his chain of command or doing drugs or, just generally being, malignant to the force. That could be a reason where they come back and say willful and persistent misconduct was the reason for the other than honorable discharge. So therefore a 3.12D bar. Lastly, still in the regulations, homosexual acts involving aggravating circumstances or other factors affecting the performance of duty. This is possibly one of the still most archaic parts of the regulation. Sure, I understand aggravating circumstances. If there was for example, the examples listed here, child molestation, yeah, I get it. But they also list homosexual prostitution down here. Or just homosexual acts between disparate ranks in the military or grade or status. What does status mean? It's a pretty damning regulation. We don't see it being used so often, fortunately, but just know this still exists as a 3.12D bar. So you don't really see it too often, fortunately, like I said, but still exists. Now, one of the big differences between 3.12D regulatory bars and 3.12C statutory bars is that a veteran with a 3.12D regulatory bar can still apply, and an other than honorable discharge can still apply for VA healthcare for any disabilities that were caused or aggravated by their military service that they're still suffering from. So there might be a little bit of a fight for that. But even without overcoming any of these regulatory bars, as long as they don't have a 3.12C statutory bar, they can still apply for healthcare for VA purposes. And that's huge. And that is going to be another way to overcome, even if you have an other than honorable discharge and less than 24 months of active duty service. If you have a service-connected disability, you can still get healthcare treatment for that specific service-connected disability. And it's usually and most commonly applied to post-traumatic stress disorder and other mental health conditions, though it can also apply to physical disabilities as well. So let's stick on with 3.12D bars for a second, because I want to talk a little bit more about willful and persistent misconduct. Now it's broken down, and the VA is working right now actually to help define what willful and persistent misconduct means. Willful is actually defined under the regulations, so that's great. Thank you for defining willful. Essentially meaning that there needs to be some sort of intent, but not specific intent. Technical violation of policy regulations or ordinances will not per se constitute willful misconduct. There needs to be some sort of willfulness involved, a deliberate or intentional wrongdoing with knowledge of. That needs to be as part of the willful. So we're going to talk about one of the ways to overcome willfulness in a moment, but arguing that the misconduct was not willful is going to be a way to overcome a 3.12D bar for willful and persistent misconduct. Persistent. Persistent is not defined under the regulations as of yet, though that's something the VA is working on. However, there must be multiple instances. I gave you that example, which would probably be more beneficial here, of the veteran who got an other than honorable discharge for that single positive test of marijuana under the Navy's zero tolerance policy of drug use. That veteran had pretty stellar military service otherwise, still got an other than honorable discharge, applied for VA benefits. The VA said, yeah, that wasn't persistent. That was one time. It can't be persistent if it's one time. So that worked out for the veteran. He didn't even need to get an attorney involved. The system worked as it should have. So that was fortunate for him, and he was able to get via healthcare, and he was not barred under 3.12D. Now, and he was allowed to apply for other VA benefits as well, even with the other than honorable discharge, because of this character of service determination that he was not barred under 3.12D because his misconduct was not persistent. So this is something where it gets a little difficult because while it's supposed to be reviewed and the determination is considered one of fact and reviewed under a clearly erroneous standard, this is something that oftentimes we have to argue as the veteran's attorney, that if the VA is saying, oh no, they're barred under 3.12D for willful and persistent misconduct, we have to argue it was neither willful nor persistent or one of the two. So important to know because this comes up, unfortunately, quite a bit. Another way to overcome a 3.12 bar is the insanity exception. So you'll learn in your years of practicing VA benefits laws, the VA likes to use antiquated terms like insanity. I even just recently had the VA deny one of our clients the insanity exception, arguing some Webster's dictionary definition of insanity. And we ended up winning that case, but it took an additional 6 months to win that case because we had to overcome a bad definition usage. So insanity is defined under 3.354 of the federal regulation. And it's defined in this lovely soliloquy of words that you can go ahead and read, but I'm going to break them down to you using case law in just a moment. So just know that insanity is not the same as, someone who's being psychopathic or not insane under the Webster's definition or the criminal definition of insanity. It's not some showing of incapacity or showing of lack of competency. Not that at all. It's got a very specific definition that's important to understand for the purposes of overcoming these 3.12 bars. Now, one of the things to point out as well is that it needs to be coupled with some sort of mental health condition. So a diagnosis of post-traumatic stress disorder is going to be helpful. If there was some sort of incident that occurred while your client was in the military, combat deployment, military sexual trauma, sexual assault, personal assault, possibly discrimination, family issues at home, something that occurred that could have caused some mental health condition. One of the things that should stay in mind is the potential of utilizing the insanity exception. So let's break down 3.354. There's several court cases under the Court of Appeals for Veterans Claims that are useful, but I like this Zhang v. Brown test. So essentially you're looking at this two-prong test, very basic, and this will help you kind of understand the insanity exception. First is that must be due to a disease. So there must be some sort of mental health issue or mental health at issue or mental health condition at issue here. Now, due to the disease, the service member either experiences a more or less prolonged deviation from his normal method of behavior, so a change of behavior. This is all coming from the regulation itself. Interferes with the peace of society, so we have some sort of criminal mischief standard or some sort of issue with the peace of society, or this is where things become a little bit more gray if they weren't already. has so departed, also known as become antisocial, from the accepted standards of the community to which by birth and education he belongs, as to lack the adaptability to make further adjustment to social customs of the community in which he resides. Yeah, that sounds like a bunch of fancy nonsense, but essentially it shows, again, going towards the deviation of behavior based off of who the how the service member previously was, or based off of their general customs or upbringing. Let's talk a little bit more about 3.12 bars to insanity. Now, these are some of the requirements that are going to be needed. Again, requires medical evidence of a mental disability. You could often use secondary sources, witness statements about a change in behavior if they didn't have a diagnosis while in service, evidence of the veteran's usual behavior, so letters from family members, people they served with, people that knew them well in service. Oftentimes, if the veteran called home or wrote home, or these days sent Facebook messages or text messages to people they know, that can be useful evidence. Hearsay exceptions do not apply to evidence rules in VA benefits cases, so you're good there. Also a compensation and pension exam as part of the VA's determination of service-connected disability benefits can be useful. More on that later, but the VA's own evidence can be helpful as well. Mental illness alone is not insanity. So mental illness itself, just because the veteran has a mental illness, does not mean that the veteran was insane under VA under 3.12. So mental illness alone is not enough. You need mental illness and. Doesn't have to be causal to the misconduct. You don't have to say that their depression caused them to beat up their first sergeant. You don't have to say that their PTSD caused them to drugs. It just has to be contemporaneous. Again, it doesn't have to be causal to the misconduct. Remember, it doesn't have to be causal to the misconduct. However, you do need to show that it was causal to one of these three factors. That the mental health issue was causal to one of these factors, not necessarily to the misconduct. So depression caused their behavior change, not depression caused them to fight their first sergeant. So we have some here, the VA's general counsel's opinions that are good to know. These are good to stay up to date on. And it's also the case laws is important to stay up to date on. Essentially, if you could talk to a bunch of people who practice this area of law, it is going to be, again, heavily on a case-by-case basis, based on your client situation. You'll hear a lot, your veterans come to you, oh yeah, but I've got a buddy who was able to get benefits and his situation's the same. I bet you it's not the same. No two situations are the same. So it's going to be on a case-by-case basis. Now, let's, and insanity, one thing to point out is insanity arguments are exceptionally difficult. They're not, it's not an easy exception to make. It takes a lot of work, but it can be beneficial. I've had two very important successful insanity exception cases for two clients that really had no other way of getting VA benefits. So it's been very helpful. Now let's talk about healthcare and other than honorable discharge. So as I talked about those two different bars under 3.12C and 3.12D, that's the interplay of healthcare. So most veterans who have a statutory bar can still receive healthcare for service-connected disabilities. That will all be laid out in the VA's administrative decision. You can get a copy of that administrative decision, whether it's through the VA directly or through the electronic benefits management system, which we'll talk about later. But just know, healthcare and OTH, it's still possible if the veteran has a service-connected disability and they don't have one of those 3.12C statutory bars. So definitely helpful. And these days, you can, the veteran themselves can apply using the VA Form 526 Easy for what they believe is their service-connected disabilities. And as long as they write for healthcare purposes in there, it'll usually be enough for the VA to trigger that. It used to be those forms had to come through the VA hospital itself, and it was a whole nonsense. But these days we're seeing a lot more of the VA coming back with positive allowances for healthcare treatment through coming directly from the veteran through that application. And coming back to with the insanity, again, they're very difficult. You have to show, you need the medical evidence. It's going to be helpful to get letters of support from people that knew the veteran. It's going to be important to highlight changes in behavior, to set baselines. We're working on one now where we had a veteran who, for the first 3 years of service, had regular promotions, stellar military service, and then sometime in his third year, all of that fell off. Started having all this minor misconduct that culminated in him getting discharged with an other than honorable discharge. And we were able to point to something that was happening in his personal life almost exactly around that time. And we've been building the evidence for that. And we've been putting together a pretty substantial case for insanity and also for a discharge upgrade. So it's been helpful. And that's another thing too, is a lot of times the evidence that you're building for the VA side of the case, or the insanity exception, or other character of service determination, it can be a lot of the similar evidence, or a lot of the same evidence that's used for a discharge upgrade to change what's actually on their DD214. So it's always helpful, and you can do both. The VA is usually quicker than the military. The military discharge upgrades are taking about a year or longer once the application is submitted and received. These character of service determinations, if all things go well, can take less time than that. And I can feel some of you who practice this being like, could they really take less time than that, James? And I said they could, okay? They probably won't, but they could. So let's talk about VA benefits themselves. And when we talk about VA benefits, we talk about compensation benefits and VA pension benefits. So disability compensation or VA compensation benefits are, generally speaking, service-connected disability benefits. These are benefits awarded due to injury, disease, or a condition that began or is aggravated while on active duty. Important to state, while on active duty. And that also means while on active duty and eligible for VA benefits. So we've got the eligibility out of the way. We open that door, assuming we got our client eligible. Let's see what they're eligible for compensable benefits. So disability compensation, and we also have VA pension. VA pension is a benefit that's awarded to low-income veterans who served during an eligible wartime period and are either disabled, and I mean disabled like Social Security standard disabled, or over the age of 65. And they must meet all of those criteria. Low income is one of the most important parts of that criteria, and we'll discuss that in a moment. Not to be confused with military retirement pension. VA pension is not military retirement pension. Completely separate benefits, completely separate criteria, and oh boy, do they pay completely separate amounts of money. So let's break this down into these two categories. So we have disability compensation and VA pension. Let's start with disability compensation. We're going to call it probably service-connected disability for the remainder of this presentation. So we're going to talk about service connection. We're going to talk about how it's rated, and we're going to talk about other considerations. So let's dive right in. So here's some criteria for disability. And you might say, James, that's really long. I don't want to read it. It's only 10:30 in the morning. What are you doing to me? So 38 CFR 3.303 outlines service-connected disability. And let's make it easy for you. Here's the breakdown. And I'm going to make it even easier in the next slide. So veteran suffering from a disability that occurred while on active duty or had a pre-existing condition that was aggravated while on active duty can be established through direct service connection or presumption or secondary service. The VA must consider a broad spectrum of evidence. Again, the regular rules of evidence do not apply for VA administrative cases. So all evidence is admissible and weighed appropriately. And let's see here. All evidence must be considered under broad and liberal interpretation in the light most favorable to the claimant. So these are all very important when there's a weighing of evidence. that is in equipoise, then the tie goes to the claimant, goes to the veteran. So that's great. It doesn't happen too often, but it's necessary and always good to argue. So let's talk about breaking down the standard for direct service connection. I try to make this easy by this 3-element criteria. First, the veteran must have a current diagnosis of a disability. So when they're applying for service connection, they have to have the disability they're applying for. It seems pretty simple, right? If your back is perfectly fine, don't apply for service connection for your back. Easy. So must have a current diagnosis of a disability. Now, the record of number 2 is they must have some in-service injury, treatment, disease, or event that occurred while on active duty that either caused or aggravated that disability. So let's go with the back condition. Veteran's got a hurt back, and they're saying that, oh yeah, well, when I was in service, I got in a Jeep accident. Perfect. While on active duty, and my back's been hurting since. Perfect. We got those first 2 criteria out the way. The third one, if only so easy, is usually the most difficult, and that is medical evidence establishing what's called a causal nexus, that the current disability, number 1, was at least as likely as not, that's the standard of law, caused by the in-service event, number 2. So that's saying that there needs to be some sort of medical evidence that says that their current back condition was at least as likely as not related to the Jeep accident that they're claiming occurred in service. Now, they could say it was the Jeep accident, it was wearing heavy backpacks, it was being kicked around too much, it was jumping out of airplanes too much. They can list the whole, it doesn't have to only be one specific incident, but it helps to be as specific as possible, especially when you have medical records at that point to these injuries. But the veteran can throw everything at the VA as much as possible, but it's good to be specific with each of these potential cause of the injury, the etiology of the injury. Now, when we talk about direct service connection, there's again governed by 3.304. There's some things to keep in mind is that there is a presumption of soundness, that the veteran was presumed to be fit for military service when they enlisted, barring anything listed in their medical enlistment evaluation. So it's good to take a look at that. It's good to take a look at their exit exams as well, their exit medical exams if they had one, which will be part of their military personnel file to kind of see what they're up against. It's not a requirement to take a look at either of those things to file a claim. You don't need a copy of a military personnel file or military service treatment records in order to file a claim for benefits. But if the veteran's denied benefits, it might be helpful to take a look at it. And we'll talk about ways to get those later on. But so there's also some additional considerations. So combat veterans, for example, may submit lay evidence of injury or disease when no official record exists. So if you're injured while downrange, while on deployment, but there's no official record of that injury happening, but you've got enough lay evidence. Again, you wrote home to somebody, you've got your own personal statement, you got buddy statements, people that you served with can tell you about it, or can write a statement about it. That will be usable evidence. Also, prisoners of war get additional considerations, and also PTSD claims are afforded special consideration. Let's go into that a little bit more under Section F of 3.304 because this is very common. So the PTSD standard for service connection is changed a little bit, and here are the 3 elements. Diagnosed PTSD, so that's the same. 2 is an in-service stressor being part, specifically tied to an event that caused PTSD. And the 3rd is credible evidence supporting that the in-service stressor occurred. So credible evidence is the standard here, supporting that the in-service stressor occurred. That's a pretty lightened standard here. So it's as you can see, veterans who are suffering from PTSD, especially those due to combat, those who have been prisoners of war, those who had some hostile fear of military or terrorist activity, and those who have been victims of military sexual trauma, rape, personal assault, while in service are afforded this lightened standard, which makes these claims substantially easier. I'll tell you from a point of practice, the most difficult part about establishing these claims tends to be the actual diagnosis of PTSD. A lot of our clients don't have a diagnosis of PTSD and instead are just given other unspecified trauma-related disorder or major depressive disorder or anxiety or something else that's not PTSD. So that can take some working with medical professionals to ensure that the diagnosis is correct. So let's talk about a different type of service connection, and this is aggravation. So getting service connection through aggravation of a pre-service disability. Again, there is that presumption of a pre-existing injury or disease will be considered to have been aggravated by service, where there is an increase in disability during such service, but only if you're able to show that that it wasn't due to the natural progression of the disease. So you need to be able to show, you still need to be able to point to, one, that you had a pre-existing injury or disease that the military was aware of, or that was cleared or was known at the time, or that you weren't otherwise going to be barred from military service for, and that it was aggravated by something that happened in service, and not that it was just the natural progress of the disease. So it wasn't just you might have had a minor knee condition that you were cleared for, and that it was just worsened naturally over time. As you can see, you may be rolling your eyes when I said that, and that's good. You're thinking in the right way. You're thinking like you should be thinking, that you should be arguing that it was not natural progression of the disease, that there was something that happened in service that worsened or aggravated the pre-service disability. This is not very common. It's not super common, but it does come up, and it's important to understand aggravation of a pre-service disability. So let's move on here. And let's talk about presumptive service connection. Now, presumptive service connection is a hot area of law right now because it's changing and just recently changed and may recently change again soon and is always before Congress. So this here is presumptive service connection, and it essentially states that there's certain disabilities and diseases associated with aspects of service that may be afforded a presumption that they're related to military service without needing to go through the direct service connection criteria. So it's essentially saying that Congress has allowed certain disabilities and diseases associated with periods of service or aspects of military service to automatically be service connected. Now we have a few here, and we're going to get into a couple of others. But go ahead, and if you take a look at 3.307 and 3.309, that you'll see some of the more details of presumptive service connection. So here are three of the most common ones: chronic disease, tropical disease, and prisoner of war related disease. Here you'll see where they have to come in to use, but let's kind of get into these. This is kind of, we're getting into that more intermediate, higher level, and I don't want to get too bogged down with these, but just know that there are certain presumptive service connections for chronic disease, tropical disease, and prisoner of war related disease. So let's get into the more common ones. Here, 3.307 also allows disease associated with exposure to certain herbicide agents. So here they're talking about specifically Agent Orange. Evidence must show that service in country in Vietnam. Also may allow for certain service members who served on the Korean demilitarized zone, Thai Air Force bases, Blue Water Navy veterans who served on the coast in the Pacific waters. All those veterans may be eligible for certain presumptions based on exposure to certain Agent Orange and other herbicide agents. There's a similar presumption allowed for veterans who were in Camp Lejeune who were exposed to contaminants, which happened for, if you look here, evidence must show 30 days of service at Camp Lejeune between this very long period of 34 years when the water was contaminated by, it was mostly disinfectant, and started with a dry cleaning plant that was upstream from the drinking water. Seems safe. And also some wartime and service on or after January 1947. So veterans who served in eligible wartime periods, as we discussed PTSD as well. So let's talk for a second because I want to an important and interesting Vietnam era presumption, because this is pretty common. And oftentimes you'll see a veteran who served in country in Vietnam who's getting service connection for something like diabetes. That's because diabetes is type 2 diabetes mellitus is a very common disability or disease. And it's also on the presumptive list of service-connected diseases for veterans who served in country in Vietnam. So that's right there, a checklist, and it's going to be the most common. Pre-diabetes, not on that list, needs to be actual diagnosis of type 2 diabetes. Recently, and many of the other ones are types of tumors and cancers as well associated with Agent Orange. Most recently, Congress had the opportunity to review three disabilities to newly be added to the presumptive list for Agent Orange, and that was hypertension, hypothyroidism, and Parkinson's disease. And I don't have that list in front of me right now, but so those were the three that were presented to Congress. Two of them were recently added. So that was hypothyroidism. Actually, it might have been hyperthyroidism. I apologize if I'm misspeaking. Take a look at that. And Parkinson's. Those were recently added to the Agent Orange presumptive list. However, hypertension was not added. However, the weird part about that is that hypertension was arguably had the most clear-cut evidence to be related to Agent Orange out of those three, and is more clearly related to Agent Orange by medical literature than many of the other presumptions. However, Congress, who has the power of to add things to the presumptive list, to add diseases to the presumptive list, refused to add hypertension, citing the costs of having to pay out all those veterans who are suffering from hypertension who served in Vietnam. So things aren't always as pretty as you wish they were, and this is the reality of politics playing into your VA benefits cases. So good luck to all those advocates out there still arguing hypertension related to Agent Orange, in the direct service connection route, and not being able to use that presumption that doesn't yet exist. So hopefully it will in the future, but right now does not. So let's move on and talk about secondary service connection. This is an extraordinarily useful tool. So secondary service connection under 3.310 allows for service connection for conditions that are approximately caused or aggravated by a currently service-connected disability. So for example, your right knee. You suffered a right knee injury in service, and you got that right knee service connected. However, because of favoring your left leg over your right leg because of that knee condition, now your left knee's busted. You can potentially get secondary service connection for that left knee as well, if you can show that it was proximately caused or aggravated by another service-connected disability, i.e. your right knee. This is very useful and can be a very, very useful tool for getting additional service-connected disabilities on a veteran's list. And it's not always as clear-cut as right knee, left knee, or right side, left side, or these bilateral conditions. Sometimes it's migraines and tinnitus and PTSD and sleep apnea and hypertension and all these other things that can be caused by a service-connected disability. So one of the things, and we're not trained medical professionals, but one of the things that we can do as a veterans advocate is take a look at what their service-connected disabilities are. Do your reading, learn about commonly secondary service-connected conditions, and do some more digging and see what can be found out about whether their other condition that keeps getting denied for service connection could be secondary to an already related condition, or maybe a condition they haven't applied for can be secondary to an already adjudicated service-connected disability. Now, James, you keep talking about service-connected disability. I get it already. They had an injury in service, they're still suffering from it. What does that mean for the veteran on a day-to-day? So once service-connected disability is adjudicated, once the VA says, yes, your disability is service-connected, they move on to the process of rating the service-connected disability, which is where things get very important. So they rate it essentially based on severity and frequency. More specifically, they rate it based on the schedule of rating disabilities which is found in Title 38, Book C. Now, ratings range from 0 to 100%, or up to 100%, not always 100%, in 10% increments based on that criteria of the schedule of ratings. It is super important to know the schedule of ratings if you're going to be working in this area. And I don't mean know it, I mean know how to read it. Because obviously it's super deep. There's a whole lot going on. You don't have to know it, just know how to read it. So, and the reason why you need to know is because oftentimes veterans will come to you and say, I'm 50% service connected for this disability, but I need more money and I think I should be getting 60% or 70%. Well, you can take a look at the schedule of ratings and actually see, is there even a 60 or 70% for that disability that they're rated for? Do they meet that criteria? The schedule of rating clearly lays out the criteria, well, clearly lays out the criteria that that the veteran needs to meet in order to meet that percentage. Now, it's important to note that ratings may fluctuate. So they can go up, they can sometimes go down, and they can fluctuate at almost any time. It's the veteran's duty to report any changes of their condition to the VA, which means whether the condition's improved or whether the condition's gotten worse. There's here listed 3 of the levels of protection for ratings decreases, starting with the most severe, that after 20 years, a rating may not be reduced after 20 years of continuous rating unless fraud is shown. So after 20 years of being rated, a veteran is pretty safe with their rating. However, before that, there can be reductions at almost any time for a finding of a change. So even if you look at the 10-year protection, the 10-year protection works for the rating being severed, for being removed absent findings of fraud. It doesn't mean that it can't be reduced. So a veteran's getting 100% service connection after 10 years, but fewer than 20 years, and their condition has improved. They may not be able to get that service-connected disability severed, but the rating can be reduced to be rated more appropriate. This can happen at any time, and it especially happens when a veteran puts in a request for a ratings increase, or when they're putting in for new service-connected disability benefits, or when they're doing anything that could potentially impact their rating. The VA can go back and make sure that they're being rated appropriately. Now, why is rating so important? Now, rating is important because the rating percentage directly reflects how much money the veterans are going to receive every month on a tax-free basis from the VA. So these are numbers based on last year, I believe, and these are just the base pay for these ratings. So 10% was $140 per month, 70% was $1,600 per month, and 100% was about $3,000 a month. And these numbers increase every year. They're proposing a pretty substantial increase in VA benefits due to the cost of living increase. I believe it was 5.6% this year. Pretty substantial increase. So that's gonna go up a lot. Now there's other factors as the number of dependents a veteran has. So after you're rated 10% or more, your rating will be increased based on the number of dependents. Also, any need for special compensation of the amount the veterans being paid, all tax-free. But one of the things that needs to keep in mind is that ratings can change, and that this 100% isn't always going to be 100%. And if it fluctuates even a little bit, it can mean a substantial decrease in this individual's monthly benefit. Now, again, when applying for a ratings increase or there's rating reevaluation, it's all to understand when you are the one telling the veteran what to do, that you know what you are doing. If the veteran says, "Oh, my condition, I need to get an increase to make because I need more money," and you tell them, "Oh yeah, just go ahead and apply for an increase," don't do that. That's negligence. That's probably malpractice, to be honest with you, because the veteran may go and apply for an increase and find out that the VA is now proposing to decrease their benefits because they didn't have the medical evidence in place to substantiate an increase. And in fact, they had stopped going to the doctor a year ago because that was too inconvenient to them. And there was no longer any medical evidence to even substantiate their current rating. So it's important to know how these things work. It's very important to understand the schedule of ratings and to understand how to read it, and also to understand the veteran's current situation. They need to and regularly go to the doctor, not just when things are bad, but if they have a substantial rating, I would say 30 to 50% or higher, especially once you get higher than 50%, they need to make sure they're regularly seeing building their file, building their record, or keeping their own personal record of how their disability is progressing, whether even if it's staying the same, and what they're doing to mitigate these things. Oh, you know, my back still hurts in the mornings, and I have to take these medications, and I'm still limited here and there and that. Because oftentimes what happens is the VA will notify of a proposed decrease in rating. Veteran only has 60 days to dispute the proposal, and only 30 days if they want to continue to receive benefits paid in the same amount that they're getting paid prior to the decrease. So things happen very quickly. It's good to be proactive here and advise your clients appropriately. So let's talk about VA math. How are these ratings determined? VA math, as it's called, or combined ratings table, as it's actually called. But VA doesn't use cumulative math to determine ratings. So it's not like 60% and 40% equals 100%. If you have a 60% rating and a 40% rating, they don't combine to equal 100%. In fact, they would only combine to equal 80%. Additionally, it's a bunch of 10% don't increase the rating as much as you would think. So if you have an 8 combined rating, 60 and 40, and then you get like 4 more 10%, you might say, well, I've got 140% of rating. No, you don't. You probably still only have 80%, because it's all based on this combined ratings table and its algorithm. There's a link there for the combined ratings table. The VA now actually does the VA calculator that you can type in the ratings and see what additional rating would lead to the new overall rating. So that's very helpful. Go ahead and look for that. That's on the VA benefits website as well. So it's super important to understand that, and to understand that it's not cumulative math. It's a combined ratings table. So that's good to know. So let's go here. Also, we have what's called TDIU, or total disability and individual unemployability, sometimes separately, sometimes together. Essentially, total disability exists when a disability or combination of disabilities, service-connected, render it impossible for the average person to obtain substantially gainful employment. You Social Security attorneys out there might think this sounds familiar, because the VA essentially stole a lot of these regulations from some Social Security. We're also looking for a permanent total disability. This exists when 100% rated impairment is reasonably certain to continue throughout the life of the disabled person. Permanent total disability is very important for property tax exemptions here in Broward County, where you may be eligible for a full property tax exemption based on permanent total disability. And individual unemployability, essentially showing that, and sorry, going back to total disability, this should read total disability and individual unemployability up here. Essentially shows that the veteran's unable to work due to a combination of service-connected disabilities. And what happens here is that if at least one service-connected disability is rated at 60, or 2 or more service-connected disabilities combined to at least 70% or more, with one of them being rated at least 40%, and there's a showing of an inability to perform substantially gainful employment due to these service-connected disabilities, the VA can pay that veteran at the 100% rate, even if they're not 100% service-connected. So what does that mean? Even if the schedule of ratings doesn't combine to 100%, if they have a 60% disability, if they're rated 60% for one or more disability, but found to be unable to perform substantially gainful employment because of that, they can get paid at the 100% rate for under TDIU, or under individual unemployability. And that's very important. Now, what comes with individual unemployability is essentially the inability to work. You have to maintain this unable to perform substantially gainful employment. So what happens if you return to work? Let's say you're only 60%, but somehow the VA finds that you're unable to work because of that because of that service-connected disability. And remember, for individual unemployability, it's only service-connected disabilities that they're concerned with under 3.340. Let's say you're determined to be individually unemployable, 60%, start getting paid at the 100% rate. 2 years later, you're like, I'm bored. I'm going to go back to work. You go back to work doing something that the VA determines to be gainful employment. And 2 years later, they find out that you're receiving gainful employment. And they go, wait a second, we were paying you at the 100% rate because you were not gainfully employable. And you go, wait, no, but I wanted to return to work. I felt better. And they're supposed to tell us that. And since you didn't inform us for all those years that you were gainfully employed, you were not eligible to get paid that additional rate of 100% rate. So instead, you should have been paid at 60%. And therefore, we're going to issue an overpayment, a debt. And now you have a whole nother issue on your hands. And we're going to talk about debts in just a moment, but a huge issue for your clients and a headache for you as well. So, and just one more tip here. That's why these ratings and understanding these ratings is so important, and informing your clients that they need to let the VA know of any changes of their condition. And it's important that you understand and that they understand what's going on here as far as reporting requirements and the fluctuation of the ratings. Now let's talk about periods of ineligibility, and then we'll take a break. But with periods of ineligibility, there's two common ones that we see. And these are periods where benefits are not payable to the veteran due to ineligibility. So first, let's talk about incarceration. So service-connected disability benefits are reduced to 10% rating if incarcerated for more than 60 days for reason of a felony. So if the veteran's incarcerated for more than 60 days because of a felony, they're not going to be getting their benefits. It's, keep that in mind, that they're not going to be eligible for the full payment of their benefits. There's some exceptions for dependents that you might want to look into if that's the case. But just understand that if you have a veteran who is going to be incarcerated due to a felony, that it's time to brush up on your ineligibility requirements. Also, pension benefits are not payable during periods of incarceration for greater than 60 days. We'll talk about pensions in a second, but those include misdemeanors. So if the veteran is getting VA pension, not military pension, but VA pension, and they're going to go to jail for more than 60 days, it's time to inform them about the bad news. Now, fugitive felon status is something that we see often. These cases tend to come in waves, where the VA does criminal background checks with the National Law Enforcement Agency. Name's skipping my mind right now, but they check for outstanding warrants. That's really all they do. They check the compare veterans who are receiving service-connected disability benefits and those with outstanding warrants. And then they mail them these fun letters saying, hey, we think you're a fugitive felon because you have this outstanding warrant and you are therefore ineligible to receive benefits. So if you don't respond within 60 days, we're going to take away your benefits and a bunch of bad things are going to happen. These cases are frustrating. Now, generally speaking, with fugitive felon status, they have to, there's essentially the standard is that they have an outstanding warrant that they're fleeing from justice. And the outstanding warrant is based on an underlying felony arrest. Doesn't always work that way with the VA. They don't care about fleeing. They don't want to even listen to your argument that your guy or girl wasn't fleeing from the outstanding warrant. Essentially, the way they like to look at it is if there's a warrant for a felony and your person's receiving benefits, they're not getting those benefits paid until that warrant is resolved. So there's a few ways to go about resolving those, but catching them early within that 30-day window is helpful. With local public defenders offices or local offices of or local counsel there can be helpful. We've been exceedingly helpful getting warrants resolved, especially when they're old, and the local public defender is just like, yeah, we'll help out. It's a quick motion. and we can get those resolved. But then you still have to deal with you often have to deal with the period of time when the warrant was issued and when the VA caught on. So just know that this area of law can be difficult. They'll start coming up in waves. So you'll start seeing one case, and then maybe you'll see another, and maybe another, maybe another. We usually see, when we see one, we usually expect at least one more to come through the door. So it's good to get familiar with this stuff and act as quickly as possible when your client finds out. It's usually new clients that find out about this stuff and they come through the door. So we're going to take a quick break, and definitely reach out to Christy or myself if you ever have issues with fugitive felons or overpayment cases. We both have handled many of these in our day. I still see a bunch of them, and I actually enjoy these cases. We've had some they're some of the most interesting cases to handle for sure. So reach out to either of us if you have questions. So I'm going to take a quick break for a second, and then we're going to come back. I'll be back in about a minute. I'm just going to refill my water, and then we'll go from there and go on our last stretch. So let's meet back at 11:04. All right, let's check here to see if there's any questions. Yeah, I see the question, and someone in the chat answered it. So thank you. The question was, when the VA does a review of a rating, do they issue a new ratings decision document even if nothing changed? Yeah, correct. Usually what happens is they will send a letter that says it's confirmed and continued. But yeah, they will issue some sort of decision. Yes. Sometimes it's usually those quick reviews, like if the client was awarded back in February and they're reviewing in October, something probably was prompted there. Either there was an increase requested, or potentially something where the veteran was requesting secondary service connection, or another reason why they would need to review that disability. But yeah, that's exactly what they'll do. Is they'll do a compensation and pension exam, a CMP exam, and during that CMP exam, part of the CMP exam is mostly based off of a disability benefits questionnaire called a DBQ, which I believe they're now readily available online again. They were off for a while, but I think you can get them again online. And those DBQs, one of the sections actually lists out, and there's a DBQ for pretty much every type of disability that you can get service connected for. And on those DBQs, there's a section that essentially lists out the rating criteria. It doesn't say like 10, 20, 30, 40, 80, whatever, but it lists out the criteria for the rating, and the examiner will check the box of what they believe meets the closest criteria. And that almost always reflects what the VA is going to rate the individual if they determine that disability, to be service connected. I swear I can talk. So it's a very useful access to the CMP exams, access to the disability benefits questionnaires. If you have a good working relationship with the VA Medical Center and some of the doctors there, that's helpful. Obviously most medical professionals, and especially the VA, are deathly afraid of attorneys because they think we're going to sue them, or we think that we're going to lie to them, or whatever. But once in a while, we'll get a VA doctor who's very helpful, and we'll be able to talk about candidly the client's condition, often with the client there, and help make a determination about whether a ratings increase is warranted, or whether this physician is going to be helpful in putting together a letter showing a more appropriate rating. So, but yeah, compensation and pension exams are excellent tools to use. For the most part, as long as you establish the first two criteria of service connection, the VA, under their duty to assist, should be issuing compensation and pension exams. We talk about that a little bit more later on in the slides, which we'll get to in this last part of the presentation. But let's carry on. So let's talk about VA. Well, let me click on this. Let's talk about VA pensions. There we go. VA pension. So VA pension, also known as non-service connected disability pension. These are disabilities that don't have anything to do with veterans military service, because if they did, the veteran would be getting service connected disability, which is generally speaking the better benefit of the two. But let's hold off there for a second, because there is a rhyme and reason why someone would want to get VA pension. Now, first, the veteran must be eligible for VA benefits. So the veteran must have been discharged under other than honorable conditions and served minimum required amount of active duty time of at least 1 day of active duty during eligible wartime period, and 90 days total. So 90 days total active duty, with at least one of those days being during an eligible wartime period, and is either permanently disabled, which is similar to the Social Security standard. They're in a nursing home, they're the recipient of Social Security benefits, or more commonly, over the age of 65. And so here we have, these are all and, so eligible, so character of service, minimum period of service, let's say age of 65, and meets VA's income and net worth criteria, similar to SSI. This has gotten even more similar to SSI over the years as they've changed and amended the rules to VA pension. Now, they look at essentially the countable income of the veteran. So they take a look at all of their income coming in from all sources, including VA benefits, military pension, Social Security benefits, employment, other pensions and annuities, any countable income coming in, minus qualified medical expenses. So countable income Then they take a 5% calculation, and any any qualified medical expenses under that threshold are deducted from deducted from the income, and the balance of that is the veteran's countable income. And then they take a look at the maximum annual pension rate, or MAPR, and they pay the difference between the veteran's countable income and the MAPR on a monthly basis. Now, we're going to get into how much the MAPR is in a second, but it's not a whole lot of money. Not a whole lot of money at all. So, this benefit is very similar to SSI. It does pay more than SSI, but it's similar in the way it's calculated to SSI. In that, there's also a assets check now as well, similar to Medicaid look-back periods. So a way to increase the maximum annual pension rate is through something called aid in attendance or homebound, or homebound and housebound. So these are two separate benefits available to a veteran and their dependents who are receiving VA pension. Now, aid in attendance requires the veterans in need of the aid of another to perform personal functions required in everyday living. Obviously, they have to also be eligible for VA pension. And this increases, the amount of money paid out to the veteran because it increases the maximum annual pension rate, and therefore increases the amount of money paid to the veteran to help cover these costs. Housebound, on the other hand, or homebound, increases the amount because the veteran is substantially confined to their immediate premises due to a permanent disability. So similar but different, same application. They both require medical evidence to substantiate the claims, and they both increase the maximum annual pension rate. We're not going too much into VA pension because it's usually pretty hard line in the calculations. Just know that it does require that the veteran does put together a comprehensive list of medical expenses, that the VA is aware and regularly aware of their income and any changes to their income, including increases in Social Security or newly found Social Security benefits, and that these numbers are regularly and frequently provided to the VA. Fortunately for the medical expenses, they give you like an entire year to provide changes to medical expenses. So even if the veteran comes to you and they're like, oh yeah, my medical expenses changed in January, you could still put that in even today and get that correctly calculated for the current year. But we're not really touching too much in VA pension. Just know, generally speaking, it doesn't pay as much as service-connected disability benefits. There are times when it does, but once you get above that 40–50% rate for service connection, it tends to pay better than VA pension. Also, service-connected disability benefits they don't care about other sources of income that you're getting. So you can get 100% service connection, and you can get Social Security disability insurance at the same time without either being affected by the other benefit. So that's important to know. You cannot get VA pension and a bunch of money from Social Security at the same time, unless the money you're getting from Social Security is under the maximum annual pension rate. You're not going to get paid both because it's offset dollar to dollar, similar to SSI VA pension is. So take a look at the maximum annual pension rates. They hover around $11,000 a year. So they're obviously they're substantially increased by the need for aid in attendance, but it's important to understand which benefit may be best for your client. The VA, however, will pay out, unless you ask them otherwise, they'll pay out the benefit that has the higher award to your veteran. So if they do have some service-connected disability, say they're rated at 40%, and their income changes to lower their VA pension, they can the VA will pay out the higher of the two, the VA pension or service connection. Let's talk about non-veterans. So spousal and widows benefits. So we'll talk about the three main types of benefits that non-veterans can receive from the VA. So at this point, these individuals are considered to be claimants, and claimants have standing to apply for VA benefits. So here we're going to talk about the first of the widows benefits, and this is DIC, or dependency indemnification compensation. And by widows, I should call them survivors benefits, because this also works for eligible dependents. Now, DIC is a specific benefit that when the veteran passes away, if they died in the line of duty or died as a result of a service-connected disability, which is probably going to be the most common for what we're dealing with, or died as a result of a non-service connected injury, and the veteran was still totally disabled from a service-connected disability for at least 10 years, or since separation of active duty, and for at least 5 years immediately preceding their death, or at least 1 year immediately preceding their death if a former prisoner. This is where you're going to have to do some research on the case-by-case basis when you're presented with a widow or a dependent seeking benefits that they might be entitled to based off of the death of a veteran who was part of their family. So whether it's the surviving spouse or eligible children of the veteran, it's going to be important to do a bit of digging to determine if any of these three criteria apply. Now, DIC benefits, this number is probably outdated at this point, but they pay a basic monthly rate of $1,319 per month to the eligible individual, whether it's a surviving spouse or eligible child, for a veteran who passed away under one of these criteria. So if the veteran was 100% service connected, receiving $3,200 a month, they're not going to be receiving that $3,200 a month anymore. They may be eligible to receive this DIC benefit. And again, it may increase based off of additional allowances, additional dependents, or additional needs as well. The second benefit that we talk about is closer to pension. See, and let's remember these things. These things flow a little bit. Compensation sounds a lot like service-connected disability, DIC. The next one is widow's pension or survivor's pension, or VA calls death pension, because again, they're really good at naming things in a compatible way. So in this case, this is going to look a lot more like how your pension benefits look. So the veteran who passed away must have served during an eligible wartime period, and you can find that on the VA's website. Make sure you're looking at the VA's eligible periods and not like immigration's eligible wartime periods. So and the applicant, or this is the claimant's income, so this is the person applying for the benefit, must be below the maximum annual pension rate that we discussed before. Again, another net worth check for the claimant. And the claimant must be an unmarried surviving spouse, an unmarried child of the decedent who is either under 18 or became permanently disabled, or 23. One of the issues here, and this is overly complicated as well, so you need to take a look at these things if you're getting approached by the widow of a veteran. And these questions should be built in to your intake applications for widows and for claimants to determine whether they may be eligible. So both questions to determine DIC benefits, and questions to determine whether widow's pension is in play. Surviving spouse has a definition under VA benefits as well, under VA law as well. It's the marriage must have lasted at least 1 year prior to the death of the veteran, and then it goes into a whole bunch of other criteria where an individual may be considered a surviving spouse if there are certain legal impossibilities for the people getting married or whatnot. So take a look at this if you see these types of cases. However, these two slides should help you understand just a little bit better the pension and the DIC benefits. The pension pays a small amount, similar to how VA pension is calculated. Widow's pension is calculated very similarly as well. The third thing I don't have a slide for, don't know what happened to it, but I apologize, is apportionment. So VA apportionment is when a non-benefit recipient claims that the veteran, the benefit recipient, the veteran, is failing to uphold their duty as a parent or as someone responsible for the well-being and care of someone of another dependent of theirs. So what does that mean? I'll give you a common scenario. Veteran receives service-connected disability benefits of 100%. That's about, let's call it about $3,200 a month. They have a child, and maybe either an ex-spouse or a current spouse or a non-spouse who they had out of wedlock. And that other individual is saying that non-veteran individual is saying this veteran is failing to pay any money towards the support of this child. They're failing to make any reasonable contribution to this child. And that individual, now a claimant, the non-veteran, puts in an application to the Department of Veterans Affairs and says, VA, I want you to apportion some of this individual's benefits to help fulfill this need of this dependent, of this minor child of the veteran who's failing to make any of these support payments. Then a whole process of some back and forth, and a reasonable amount of time for due process goes through to allow the veteran to show, no, I am making this support, and allow some back and forth of evidence to be exchanged, and then the VA makes their apportionment decision. I'll say commonly, and Christy and I were talking about this before we went on. I've been seeing a lot of cases recently of apportionment cases being filed where we then talk to the veteran, and the veteran's going to be our client in this case. We talk to the veteran, and the veteran says, I'm paying child support, court-ordered child support every month. And we'll take a look at the court-ordered child support. We'll see, yeah, they are indeed paying court-ordered child support. Then we'll take a look at the apportionment, and guess what? Court-ordered child support was not listed in the sources of income that the claimant was listing. So you got to be careful with those apportionment cases when your client is on the other end of the apportionment. Be mindful and take a look at everything that's being filed and make sure you're asking the right questions. But the apportionment can be a fairly complex area of law. There's different types of apportionment and different ways to fight different types of apportionment claims. So just keep that in mind. Now let's talk about representing parties before the VA. So this is kind of the home stretch of everything. And let's talk about the accreditation process. As many of you know, if you're already accredited, great. If you're recently accredited, awesome. If you have any questions about accreditation, here's your slide. There's that accreditation mailbox I was telling you about. They're generally pretty good at responding to you. If you are if you're working in a legal aid setting or a clinical setting, and you want to do a clinic where you need a bunch of people accredited quickly, you can ask them through the accreditation mailbox and say, hey, I've got some people who we're doing a clinic in the next couple of weeks. Could you expedite these applications for accreditation? And they usually will. There are standards of conduct found here under the regulation, so take a look at those if you're accredited. There's certain CLE requirements that you're going to have to meet, and you're going to need to make sure you stay on top of that. Usually the VA will remind you if you're falling delinquent to the CLE requirements, but you're also going to have to show yearly that you're still in good standing with the bar. Fee agreements, something that a lot of us don't have the pleasure of dealing with, but something that I'm required to talk about as part of this accreditation slide. So accredited agents and attorneys may charge a fee for their services. However, there are specific rules and regulations regarding when and how fees can be charged under 38 CFR 14.636. So this essentially governs the when and how direct payments can be received. Not really important for you and me and all of us who are doing the pro bono work. However, recently, I guess it's not really recently anymore, there was a change that allowed nonprofit agencies to charge a fee as well under these fee agreements. That could help, obviously not go into your pocket, but to help fund programmatic costs. So take a look at that. We decided down here not to do that. But if your program is in a place where you need to do that, or you think that's appropriate, that's going to be entirely up to you. Go ahead and take a look at those rules as well. But essentially, the fee agreement requirements are there in 14.636, and there's presumptions of reasonableness, just like in some other aspects of civil law. Floats right around that 33.3% of the award. And so the way the fees are paid out is any retroactive pay, any retroactive lump sums of money paid to the veteran, a percentage of those would be paid directly from the VA to the attorney or the veteran's appointed representative. So keep that in mind, that you can get paid for this stuff, surprisingly. Important forms. Here's some important forms to keep in mind. All these can be found on the VA website, but a lot of these forms are referred to by their short caption name. So 2122A is the form that allows you to get appointed as the individual or claimant's representative. And this is the form that you'll be using as an attorney. I suggest that if you're practicing this area of law, create a PDF for this form and fill in all of your information already. It's going to save you a bunch of time of typing. And then all you need to do is either fill in the veteran's information when they're there with you and print it out and go over it with them and have them sign it. Or another thing that we found handy is that we highlighted the areas that we need them to complete when we're mailing out packets during the pandemic. We've had to resort to mailing out a lot of intake packets. I found that highlighting the specific areas that need to be completed by the veteran prevent them from filling out all the areas, including the part where they are agreeing to payment agreements and whatnot. But don't worry about that too much. If they do fill it out, it's not a big deal. But yeah, very important form to keep in mind. This is commonly called the 526 or 526 EZ. This is the claim for compensation benefits. We also talk about the other types of forms here that you might see on a regular basis. Let's quickly get through this so we can get some more good information here. So important numbers. We have the VA customer service line. There's a VA attorney line as well. If you don't have that number, it's useful. If you don't have VBMS access, then this is probably the line you're using. If you don't have VBMS access and you're practicing VA benefits law, best of luck to you. Hopefully you do a lot of praying and a lot of meditation and mindfulness. VBMS is transformative to the practice of VA benefits law, but hold that thought, we'll get to that in a second. Debt management, this is the debt management number for any overpayments. Debt management will accept applications for waiver through this email address. They will. I suggest if you're emailing debt management or a debt waiver set email address, you also fax it to the, this shouldn't say regional office fax number, but send it to this fax number as well. This is the claims intake center. They're one central claim intake center now for all regional offices. This is one of the only phone numbers that I remember other than my wife's phone number and my mom's phone number is the VA regional office fax number, because I still send everything there electronically through fax. It's super helpful. But yeah, these two numbers up top are good for your clients to call, and everything else is good for you. But let's talk about that VBMS thing I was mentioning. So Veterans Benefits Management System, or VBMS, is the electronic system used by the VA, VBA, to manage all VA benefits claims. Not VHA. VHA uses a different system. This is the VBA's system of how they manage all VA benefits claims. If you're a veteran service officer, then you generally have pretty good access to VBMS. If you're a lowly attorney like us, you have to apply for access. Now, this began back in 2010 as a pilot project. In 2013, all 53 offices started processing claims through VBMS. Almost all of your clients' VA claims file have been transferred electronically through VBMS. I'm not seeing any anymore. I used to once in a while see one of them that come back and say, oh, you know, that's not yet uploaded to VBMS. But I have not seen that in years now. So you can get VBMS access once you submit your 2122A if you've already been pre-approved. You have to go through an approval process for VBMS access. If you want to know how bad it is, this is what I sent to Christy a few years ago. The 17-step process of the VBMS flowchart. It involves a lot of trainings, a lot of calling people. I wish I had the time to go through all of this because there's some funny things in there. But it's a lot of back and forth with the VA, with the regional office. If you're not close to a regional office and you're getting your fingerprints done at a healthcare center that's closest to you, they're going to look at you like you have 10 heads when you go up there and you say, I'm trying to get VBMS access. And they go, what? So they don't know what that is because that's not a system they're familiar with. When you then realize, oh, I have to tell them that I'm getting a PIV card, they're like, oh, do you work at the VA? And you say no, and they say, well, you can't get a PIV. So it takes a lot of patience and understanding what you're actually doing in order to get access to VBMS. But essentially, it involves you getting a PIV card, which I've got right here in one of these cool little holders. It involves you getting the fingerprinting done and the background checks and the clearance, access to VBMS, downloading the right things and calling the help desk and logging in and freaking out because it's very scary when you're on a federal system that there's a bunch of things on there that seem like if you're going to click, you're going to be thrown into federal prison just for accessing accidentally. But once you get the hang of it, it is amazing. It used to take months and months and sometimes a year or more, or sometimes never, to get a VA claims file or military personnel file or service treatment records or VA medical records that are used in conjunction with a claim. But now we complain that it takes 10 days to get access to VBMS after we submit the 2122A. So it's a game changer and it is amazing. And if you don't have access to VBMS and you don't know anything about VBMS, but you're practicing this area of law, let Christy and I know. And yeah, it's going to be very helpful. I'm happy to help you get VBMS access however I can. But it starts at your local regional office. Christy's currently having issues right now where she's in the throes of this process. So she's been through it now a couple of times. So I'm sure she'll be more than happy to help you with this. But yeah, important to know. So let's talk about some of the parts of the claims, benefits claims when we're talking about appeals and claims procedures from start to finish. And we've got about 30 minutes left here on our presentation. So bear with me and thank you all for sticking out for the rest of this. So now when we talk about initial claims for benefits, we're going to be talking about ways to file these claims, VA's duty to assist, reopening claims, and the C&P exam and the appeals process. So ways to file claims for service connection. Some of you out there who have been doing this for a while will help your veterans file claims, new claims for benefits on the 526EZ if it's a claim for compensation, or the 527 if it's a claim for pension. Some of you may not be in a position to do that and may work with a local veteran service officer or clinic or whatever it might be and send all your clients there. Some of you may do it on a case-by-case basis like we do here at Legal Aid, where some clients will help with the new applications for benefits. If an attorney helping them will make a difference. Now, if it's not an initial claim for benefits, meaning if it's not the first time that they filed this claim for benefits, if they've been previously denied, whether it's a year ago or 10 years ago, more than a year ago or 10 or more years ago, or anything in between, they're going to need to file it on a supplemental claim. So that is if they're no longer in the appeals process, or in the appeals window, if they're no longer within that 1 year appeals window, which we'll talk about in just a moment, but they've already been previously denied for the claim, it needs to go on a supplemental claim form. If it goes on the 526EZ, the VA may kick it back to you and say, this claim's already been previously decided. They're going to have to submit what's also called new and relevant evidence. It used to be called new and material evidence, but these days called new and relevant evidence in order to reopen that claim for benefits. Now, the new and relevant evidence can be pretty broad. We've gotten lucky enough to have these claims reopened just by submitting a statement that the veteran had not previously mentioned to the VA. So a statement about their military service that was not previously considered by the VA. New medical evidence helps. Any new and material evidence will help. So filing a claim for a new claim for benefits, we have something called a fully developed claim, and that's when you have everything ready to go, all the evidence signed, sealed, delivered. You're telling the VA, this is our claim, we're filing it. Now, ultimately, the veteran is responsible for submitting all evidence required to support their claim, including VA medical records, military personnel files, military medical records, those are service treatment records. However, you're going to learn in a second that the VA also helps out with this. So with that being said, that does not mean that the veteran needs to have in their possession their VA records. It does not mean they need their military personnel file and their service treatment records before filing a claim. They do not need that. Ultimately, it's their responsibility. However, they can file a claim for a fully developed claim with the VA, submitting everything that they have or anything that they have that's relevant, including personal statements, statements in support from friends and service members, that buddy statements and people they served with, private medical records, anything they might have, they can submit that with the claim. Or they can also submit with the claim where their private medical records are located, which VA facilities they were getting treatment at, and they can list all and when they received treatment there, where they served in the military, and where any specific military records may be. So any specific they may have received at a certain base or government facility. And they can send that to the VA, and the VA then has what's called a duty to assist. And the VA's duty to assist essentially says that the VA has a duty to help the veteran or the claimant substantiate their claim by gathering the evidence that the veteran's pointing to. As I mentioned, it's still ultimately the veteran's responsibility, but the VA has a duty to at least attempt to get this evidence on their behalf, as long as the veterans told the VA like that evidence exists. Obviously, if the veteran, if the claimant doesn't say, oh yeah, that I got treatment here, obviously there's no way the veteran is going to be reaching out to every VA medical center for assistance there, or for records there. So this is very, very important. This includes the VA's requirement to issue a compensation and pension exam when necessary. It includes the VA's requirement to productively review those compensation and pension exams. And I'll tell you, a huge basis of the appeals process is based off the VA's failure to fulfill their duty to assist with developing these claims. So oftentimes, an inexperienced advocate may look at a claim and be like, oh, there's really nothing we can do to help you. I can almost guarantee that, anecdotally, 9 out of 10 times, there's some sort of duty to assist claim there. And oftentimes, we've taken some of these claims up to the Board of Veterans Appeals. They've been remanded for proper instruction, where at the time, after the proper instruction and new C&P exams, the claim has been successful with their claim for benefits. And, unfortunately, it took them a long time, but they're rewarded a pretty handsome retroactive pay. So let's keep in mind that not all claims are clear, and oftentimes the VA's failure to uphold their duty to assist is grounds for appeal in itself. So the importance of keeping that chain of appeals together is the effective date of claims. And the effective date of claims, and we'll talk more about the appeals process in a moment, but the effective date of claims is generally the day after discharge if the claim is received within 1 year of release. Otherwise, it's the date of when entitlement arose. Now you say, James, why does it have to be so vague? Again, the date of entitlement, what does that mean? Yeah, exactly. Usually it means one of these 3 potential dates. So if the application was submitted within a year of release of active duty, it's usually the date of discharge from active service, or it's the date of the receipt of the application for the claim. If the appeals chain was not broken, meaning if each appeal was submitted within a year of a denial, and generally speaking, it's going to continue to retain that effective date of the receipt of the claim, or slightly earlier if they submitted what's called an intent to file. So it could be the date of the receipt of the claim or the intent to file a claim. Or lastly, the date of when entitlement arose. This is most commonly used when there's new evidence that came up to substantiate a claim. So veteran files for PTSD or any mental health condition in 2015. They get denied. In 2016, they appeal the claim. Finally, in 2017, there's some new medical evidence during the appeal process that comes up that says, Oh, yeah. Well, while we said before that the veteran had no mental health issues, now we're saying that they did. The VA may likely say, well, this new medical evidence changes the date of entitlement because entitlement only arose when they were actually diagnosed with the condition. So they may try and get you and say the entitlement was 20 and not 2015 when the veteran filed the claim. That's probably going to be on appeal, and you can also appeal the effective date. So here we talk more about that. That's just what I had mentioned with some of the issues, and you can appeal those effective dates if needed. Intent to file a claim. This is something that can be done if the veteran doesn't wish to file a claim right away. They can either file an application for an intent to file a claim. They can start an application on the e-benefits portal. They can call the VA through that hotline number that I put up there earlier, and have their intent to file a claim. Then if they file a claim within 1 year, that the effective date can go as far back as when they filed that intent to file a claim. This does not apply for supplemental claims. If they file an intent to file a claim and then file a supplemental claim, the date is almost always going to be that supplemental claim because of what I mentioned earlier about the date of entitlement. So be careful with that. Other evidence supporting a claim here, this is something we've talked about a few times. The disability benefits questionnaire, the veteran's personal statement, a buddy statement, statement from a family member, other forms that I mentioned in the previous slide of important forms, and anything else. Remember, the rules of evidence, the traditional rules of evidence don't apply here. So any evidence that you think is going to be helpful is probably going to be helpful. Talking about compensation and pension exams, I believe that these are some of the most useful tools for substantiating claims. I hate when veterans say, I'm not going to my C&P exam. Well, you're probably not going to get your claim granted. There's case law stating that the VA cannot just deny a veteran's claim for failure to appear at a C&P exam, but I'm going to tell you they usually do. So a C&P exam is something that will usually be scheduled. The veteran will get a call. They'll either call it a MIE or an offsite C&P exam here in, I believe, all of Florida now. I know at least the Miami VA does not do any C&P exams on site anymore. They're all outsourced. Independent medical examiners, IMEs, that's what they're called. So the C&P exam is super useful. It's less of an exam and more of a questionnaire. And you can prep your clients for these things. Obviously, don't tell your clients to lie about things, but it helps to tell them what to expect at the C&P exam. So filing a claim for non-service connected pension these days can be exceedingly difficult. I strongly suggest that if you do not have an elder law background, that you get an elder law attorney involved. Or someone who is well-versed in non-service connected pension, unless it's a very simple, straightforward claim. Mostly, you're going to need to get someone who is well-versed in these cases involved if the veteran has assets, if they have substantial inheritance, if they have non-homestead property, if they're receiving regular distributions, if they've recently transferred property, that's when you want to get an expert involved. If they don't have any assets and they just have and they don't have any other income and they just have some unreimbursed medical expenses, then yeah, you could probably do it yourself or with help from a VSO, but you want to make sure you're following all the rules and that everything's in place. Another thing is if you are doing this, or if you work with VSOs that do this, or if you train people on this area of law, please tell them to tell their clients that if they're applying for VA pension, and also applying for Social Security benefits, and they get their VA pension granted first, and they later get Social Security benefits granted, they need to tell the VA that they started getting Social Security benefits. Put that in writing, tell them that they did it, because the last thing you want is the veteran got the VA pension first. At the time they got awarded VA pension, they weren't getting Social Security benefits, so it wasn't part of the calculation. Then a couple of months later, they got Social Security benefits. Then for a couple of years, they continued to receive both benefits, with the VA not knowing that they should have been offsetting the VA pension a little bit or a lot of it from the Social Security. and an overpayment's issued. And then they come back to you and they go, my attorney didn't tell me I needed to do that. Yeah. So make sure you're telling them that if you're handling these types of cases at all. Decision letter. So the VA will issue a written decision. They have to issue a written explanation how they decide the claim. They have to. It's a requirement. If you didn't get one, call your regional office and tell them, hey, my client needs you to resend that written decision letter. If you're the attorney of record, they'll be sending one to you as well. These letters have to include the evidence that was used, a breakdown of each contention, and the veteran's right to appeal. I'll tell you, you'll be woefully impressed with the breakdown of each contention and the rationale. It's mostly copied and pasted from a canned answer, sometimes incorrectly copied and pasted. So just keep all that in mind, that, you know, when you're reading that stuff and you start reading some really crazy things that don't apply to your client, make sure you bring those up, but bring them, just raise and dismiss them. But yeah, those decision letters are important. You should be receiving them. I've got a case now where we haven't received the decision letter yet, so we're going to have a fun time with that. Right to appeal. So there's appeals processes that are now currently in place under the AMA that went into place in February of 2018, or went to law in February 2018, and have slowly been phased in since. So for the most part, in the old way, in the legacy appeals, which you may still have a case here and there under legacy appeal, the client had to file a, prior to 2019, when all claims went under the AMA, the veteran had the opportunity to file a notice of disagreement. There's one page saying why they disagreed, and they can ask for a de novo review of their case by a decision review officer, or or they could also elect to jump into the new system. So here, let's talk about the new system. These three appeals are your three appeal options after the denial of an initial claim. So if your initial claim is denied, you have 1 year to file either a request for higher level review, or 1 year to request a review before the Board of Veterans Appeals. Higher level review is useful if your argument is a failure for duty to assist. I like to file the higher level review if my contention is with like the compensation and pension exam. A higher level review is useful. I'll always advise my clients, listen, we should try the higher level review because it's going to be quicker. And I think we have a chance if the VA agrees with our argument. They're not always going to agree. But you will usually get a quick response to your higher level review saying, no, we disagree. At that point, if you have new evidence to submit, that if any new evidence has come along, you can submit a supplemental claim. If you don't have any new evidence after submitting your higher level review, or you didn't ever have new evidence and you don't want to do a higher level review, you can go right to the Board of Veterans Appeals, do a board review. Now, this is a lengthy process. It takes a long time. It's probably going to take, I like to advise, at least, it's going to take longer than a year, though I cannot tell you exactly how long it's going to take. If they're requesting a hearing before the Board of Veterans Appeals, it's going to take even longer. If they don't want a hearing, then it might not take so long, but it's still going to take over a year. Once it gets to the Board of Veterans Appeals, I think I have that. Yeah, I have that on my next slide, so we'll get there, how the BVA. But yeah, for the most part, the board is the first time that you're getting a lawyer through an administrative law judge and their law clerk to review the case. Generally, this whole process is considered non-adversarial. I guess technically when you file the appeal to the board, it's adversarial, but if you ever have been to a BVA hearing, they tell you this is a non-adversarial process. We're here to help out. I've had some very good outcomes at board hearings. If your client is on the fence about having a board hearing or not, I'm always, as an attorney, a little hesitant to have my clients who are not going to be good witnesses take board hearings. But if the client wants a board hearing, advise them of the pros and cons of having a hearing before the board. On a board hearing, they are welcome to do a bench review, if you will, or a desk review for the Board of Veterans Appeals. It's actually called a case review in from the BVA, where the board doesn't bring in the veteran, they just review the entire file, and the administrative law judge then makes their decision. That's going to be substantially quicker. Since the pandemic, all board hearings have been remote, and it has been amazing. If you have not had a remote board hearing yet, it's great. It is just the most wonderful thing you'll ever experience, and I strongly advise the VA and hope that they will continue to do remote board hearings forever as an option. Remote board hearings through a virtual platform, those things need to stay because they are amazing. So thumbs up to the VA for doing that. That's great. So let's talk about a supplemental claim, because I've kind of left that one blank. Supplemental claims are used when you have new evidence, new and relevant evidence. You can file a supplemental claim within a year of getting the decision letter, or if it's been more than a year and you want to take another shot at that claim, you can file a supplemental claim. It doesn't have to be within a year. However, if it's filed within a year, then you have a chance of maintaining your earlier effective date of when the initial claim was filed. You have a chance, though a supplemental claim, the VA may try to argue that the supplemental claim was an intervening action that established a new effective date. We're starting to get into some more advanced stuff. Just know the appeals process is it can be fairly complex, and there's a lot to understand. It's not just, oh yeah, let's just file this. It's not as easy as it used to be, just filing a notice of disagreement and moving on. So talking about deadlines, generally speaking, the first main deadline when it is an appeal for the denial of benefits is a year. If it's a contended claim, meaning if it's the VA saying that they have proposed to reduce your benefits and they're taking away your benefits, or they're reducing your rating or anything like that, issuing an overpayment, something that's not an appeal for a new benefits claim, if it has something to do with money usually, those only have a 30 or 60-day response window. So know where you're at, read the decision letters, and know what you're operating under. After the appeal, the VA issues what's called a statement of the case, and that's the VA regional office's final administrative determination. I wrote decision, that's wrong on me. The VA administrative determination about the case. After that, you're really going to the Board of Veterans Appeals using a Form 9. The Court of Appeals for Veterans, once the board has decided, and here, once the VA, I was reading the chat, once the VA statement of the case is there, you have 60 days to appeal to the Board of Veterans Appeals using a VA Form 9 if you're not there already, or at any time you can file that supplemental claim. Once it gets to the board, they can either grant the case, deny the case, or remand the case back to the VA regional office. Now, usually, the majority of cases at the board are remanded back to the VA regional office for further processing with specific instruction. I like to inform my clients that that's generally a good thing. That's not a bad thing. The board could have denied your case. The board may also grant the case. We've had a few cases granted at the board, or they could take any action on certain contentions of each claim. We recently had a 6 contention case where 5 of them were denied and 1 was remanded. So that can be the case as well. If the board denies a case, then you're off going to the Board of Veterans Appeals. You're off going to the Court of Appeals for Veterans Claims, the federal appeals court that hears cases on appeal from the BVA, and that's where binding precedents may be formed. Not all court decisions from the CAVC are binding. None of the Board of Veterans Appeals cases, in fact, are binding on anything other than the case at hand. So you might have a really awesome BVA case that says like, oh, your client should be granted the insanity exception for these reasons. You go, yeah, I want to use this on my other insanity case. It's unfortunately not binding on other cases outside of your case at hand. However, the BVA does a pretty good job in their decisions, in their opinions, citing the applicable federal court case law. So go ahead and borrow some of that case law if you want. BVA decisions can be searched at the bva.va.org. It's one of the websites I wrote in the resources, and can be a wealth of information on persuasive or case law that they've cited, or just maybe how the board has decided similar cases to yours in the past. So I always add the BVA case search as part of my research for new cases. Let's see if there was anything that I have missed here. Nope, you should be good. Just understand that this VA appeals process can be very lengthy and very frustrating for your clients. In the perspective of your clients, many of them have been going through these appeals or these benefit applications for a decade or longer. Sometimes they filed a claim when they first got out and they got denied, and then they waited years and filed a supplemental claim and got denied. And now they finally are coming back and they filed again and they got denied again, but now you're on their corner and maybe there is new evidence. So they might say things like, you know, for you, this claim's only been going on for a year, but for them, they've been fighting this for 10, 15 plus years. So, you know, be mindful of that when you're working with your clients through the appeals process. It's the best thing you could do, or at least the most useful thing that's worked for me, is to be clear on expectations and be sympathetic of their concerns and whatnot, and be encouraging of them to continue, especially those that have that you can see a clear outcome for. Because I've had clients before that have been discouraged. You know, should I really be appealing to the Board of Veterans Appeals? Is anything really going to happen? And that's where I'm able to explain to them, listen, like this is what the board can decide. This is what I feel is strong about your case. However, we don't know what the outcome is going to be, but there's only one way to find out, and we're here to help you. So, you know, I'm encouraging them to do the right thing, but obviously listening to what they want to do. They're the clients, they're driving the ship, but just being there as a sounding box and providing your opinion can be helpful. Now, with that being said, let's talk about some resources for veterans. And this is just a little slide. This is actually the last slide of the presentation. So some resources for veterans, Mission United. If you don't have the Mission United in your area, shame on your United Way. No, I'm just kidding. Go talk with your United Way, talk with me. One of the things that we'll be working on over the next coming years is really solidifying the positions between the United Ways throughout Florida and their Mission United programs and their involvement with their legal service providers. As many of you know, as those folks that are boots on the ground, legal services are some of the most important aspects, some of the most important services of a well-rounded, holistic service that can be provided to veterans. Legal assessments, as if you're involved with supportive services at all, and you know, SSVF now requires SSVF providers to link up with legal aid or legal service providers or attorneys to provide that service to veterans enrolled in SSVF. That is exceedingly important, and it's clear that the VA sees it's important. I think that these programs should also, any veteran service providers or veteran service organizations should realize the importance between legal services and the veterans they serve. The FDVA is great. Here in Florida, the FDVA is wonderful. If you need legislative stuff passed through, both the Mission United programs, the FDVA, United Way of Florida, all great ways to get legislative things pushed through. They're always looking for, and I can now say we're always looking for stories from you, from the practitioner, about your clients, where you know, maybe there's a legislative tick. Like my client was having this issue, and I'm regularly seeing this issue. If you're an LSC funded program and you're worried about doing any lobbying or talking about policy, you don't have to. LSC has approved, and you know, obviously get this approved with your chain of command before you do anything. But on at least on our end down here, LSC has approved talking with people about issues that their clients are facing. So not saying, hey, we need this law change, but instead saying, my clients are really having trouble getting food stamps because of a lot of them are just being seen as ineligible. Well, that's an issue that a program can take and say, well, we can work with that. We can put policy with that. Put a shield up with the LSC provided program. We don't need them anymore. They told us about the issue. We're not going to get them involved. We don't want to mess around with any LSC requirements, but talking about issues that your clients are facing can be very helpful. VA medical centers can be helpful. Vet centers can be helpful. VSOs, groups like the DAV and American Legion. All of these resources for veterans are places that you as practitioners should be linking up with, do clinics, give presentations, give whatever type of community resource events that you're putting together, veteran stand downs if you can, and reach out to veterans and let them know the services that you have to offer and let them know that you're there. So that was this presentation. I successfully talked for 3 hours. I don't think my employer is here, so I'm going to go take a nap. But if anyone has any questions, as always, please reach out to myself, reach out to Christy. We're here to help. As I mentioned previously, I'm going to be changing roles a little bit and taking over as the Senior Director for Mission United here at the United Way of Broward County. It's only going to put me in a position to help further all of your programs and help really expand the information and the knowledge about the great need for legal services and just the expansion of services outside of the VA for veterans all across Florida and nationwide. So please reach out to us and let me know. I see there is one question, so I'm going to take a second to answer that question. But if anyone needs to go, I have the actual cert that we can send out if people would.
Okay, great.
The training.
I'll add that to the shared folder. And thank you so much, James. That was a marathon. You're the probably only person I know who can make a 3-hour training interesting the whole time. We didn't lose any attendees or anything during that long training. So thank you so much for doing that, especially after Thanksgiving. And I can't wait to see what you do in your new position.
Thank you. I'm very excited. It's bittersweet. I've been thoroughly enjoying my time at Legal Aid. I've been here for almost 6 years now, and it's been an amazing opportunity. But this is how careers work, right? One thing, I'm going to leave up this fun slide. So if anyone's got, if anyone wants to read out the process for the BBMS flow chart.
This is how it is in Florida. Other states might be nicer, but that's how it is here. And I think I can speak for both of us. So James and I are both kind of nerds when it comes to VA stuff. So if you have some kind of sticky case that you want to bounce off somebody, we are always happy to talk about this stuff.
And I also want to take a moment to plug a resource that's been very helpful for me as well, and that was the American Bar Association's Commission on Homelessness and Poverty. As a young attorney, I got involved with the ABA and learned a whole lot about their other amazing programs, the Veterans Consortium, LAMP, which is an amazing pro bono program out of the ABA. And from that, learned the importance of bar service. The Florida Bar has the Military and Veterans Affairs Committee, which if she hasn't been kicked off yet for being on it for too long, Christy and I both serve on there. I'm currently the vice chair of that committee, and it's so important to be involved with bar service, both at the national level, the local level. You'll meet so many amazing advocates. You'll learn so much, and it's great. It's a great way to spend your free time. So thank you so much. I'm going to take 1 second to read this question here, but if you've got to go, you have been dismissed for your 3 hours. But let's see here. In Florida, there's a 5% allowance for fees to a VA guardian, along with any other federal benefits. However, the VA manual notes 4%, which also confirmed by the hub. Is this allowable? That's a great question. A bit, unfortunately, outside of the scope of this presentation about the local allowances under Florida law. But if anyone knows that question and wants to follow up with me, I'm happy to follow up. I actually don't know the answer to that. We don't do any guardianship work here at Legal Aid. Unfortunately, I wish we could, but.
And I did want to announce the CLE number, which I put in the chat, but in case you can't see it, it's 2106704 N as in Nancy. Again, that's 2106704 N as in Nancy, and that will be sent out with the recording and the PowerPoint. And anything else we mentioned during the presentation, I'll get that all into the shared folder. There's no certain form for submitting these credits to the VA. As James may have mentioned, the VA is interesting. I've never heard back when I've submitted credits. I mean, I'm still on the accredited website, so I assume I haven't been kicked out, but you will never hear back. So, I mean, you could just email the accreditation inbox with the CLE number and the credits, and I have never had anyone respond. I don't know if you have, James.
I've only had someone respond when I forgot to add something to the email. So, but no, I've never had anyone respond telling me. I have though one time, I'm so neurotic. I sent an email to them after I didn't get a response, and then they said, "Oh no, you've submitted everything." So I think I sent like 3 emails. I was like, "I haven't heard a response. Am I still accredited?" So yeah, don't worry too much if that's happening, but yeah, they'll let you know for sure if you're not. But yeah, I'll send you to Christy. I'll send you my form email that I sent to them for accreditation. You have to, I know every year you have to send them your eligibility or your certificate of good standing for the bar. With Florida, that's really easy. You just go on the bar website and print it out or save it as PDF. But then every other year or every 3rd year, you have to send them proof of 3 credits.
I do it every year because otherwise I will forget which year I'm on. So just to be safe, but yeah, do not be alarmed if you never hear back from the VA. And in spite of this flow chart, I mean, it is a pain. My account got deleted this year. I had to go to the VA in St. Pete twice to get it back. But with all that being said, it is absolutely essential to get BBMS access. It will change your life as an advocate.
It really, really is. And I just think it's, again, it really does. It's game changing.
It's worth all the trouble. Well, we will let you guys go. Thanks for hanging in there with us. James, I hope you can see all these compliments in the chat box. Everyone enjoyed the training, and we'll definitely miss you in Veterans World, but we'll pull you back in for another training next year for sure.
Absolutely. I'm always happy to do trainings. I'm still going to be doing VA work very closely, so I'm not going anywhere.
Fantastic. Well, thank you everyone for joining today, and feel free to reach out to us with any questions. Otherwise, check your email and your spam folder for the Zoom email tomorrow with all the great materials and the reporting. Thank you so much, James. Have a good week, everyone. Bye.
Bye, everyone. Thanks for coming.